Welcome, everybody. Welcome to today's episode of The Law of Self-Defense. I'm not hearing myself at all, but it sounds like you folks are hearing me. All right. So that's good. That's nice to see. Let's make sure. Oh, that's working. It looks like everything. How about X? Do a little refresh there and pin that. And we look like we're good to go. We are here today, of course, for day 10. Day 10 of the Hannah Gutierrez trial. Manslaughter trial for the armorer Hannah Gutierrez over the shooting death of cinematographer Halyna Hutchins on the set of low-budget Western Rust. Halyna Hutchins being, of course, shot and killed by the actor Alec Baldwin, whose trial is coming up on August 6th. Also a manslaughter trial for having fired the shot that took the life of Halyna Hutchins. Let's see. All right. So the highlight of yesterday, quick recap of yesterday while we're waiting for the court screen's on, but nothing's happening yet. Make sure the volume is up there so we're ready when they start. Yesterday, the defense began to present its case in chief, and it finished its case in chief. Well, not quite. I guess it has a couple more witnesses today. 4 witnesses yesterday for the defense. 2 of them were from the New Mexico version of OSHA. They talked about how they fined the production of Rust $100,000 for various safety violations. Of course, that really has nothing to do with Halyna Hutchins. Their mandate is only to investigate employers, not employees. So it was all rather pointless. And then they had as their third expert witness, a private detective, Scott Elliott, worked for the defense, had all kinds of complaints about the quality and nature of the investigation done in this case, none of which had anything to do with anything relevant in this trial, anything to do with the prosecution's actual theory of the case. What's the theory of the case? There's only one legal question in this case, and that legal question is, did Hannah Gutierrez hand over into the set in the church a gun, a real gun, that she'd prepared that was supposed to be cold, not capable, not loaded with live ammo, and it had a live round in it? I mean, it's really irrefutable. Hannah herself says that she's the one who loaded the gun. She loaded 5 rounds before lunch. She says they were dummies, and she loaded a 6th round after lunch. She says it was a dummy. Clearly, the gun had a live round in it. That round killed Halyna Hutchins. So there's no evidence that anybody else did anything with the ammunition of that gun in the 5 to 10 minutes between when Hannah Gutierrez handed it into the church and Alec Baldwin fired the shot that killed Halyna Hutchins. There's no evidence. I know the feminine emotionalists in the chat like to talk about, well, what could have happened? Let's speculate. For all we know, Assistant Director David Halls took possession of that gun, and in a room of 10, 12 people, photographers, cinematographers, lighting people, special effects, wardrobe, script supervisor, Alec Baldwin, Joel Souza, Halyna Hutchins, in front of all those people, he opened up the loading gate, pulled the hammer to half cock, took a dummy round out of the gun and put it in the gun, put a live round in the gun. Any evidence of that? Does it sound credible? Or we have to believe that Alec Baldwin did that. Same circumstances. It's ridiculous. Ridiculous. So, I mean, there's really nothing for the defense to do on the legal merits, except a bunch of smoke and mirrors. So the detective complained about things like the lieutenant on the scene picked up the revolver with no gloves on. So what? We know there's no dispute about which gun fired the shot. It was all ridiculous. And he was so embarrassed by Karen Morrissey on cross. I almost felt bad for him. But the guy, it looks like the guy had a Ranger tab on and he'd served in the Army. So kudos, sir. Thank you for your service. But there was nothing he could do for the defense here. And then the last witness of the day was, of course, the defense gun expert. Their gun expert, Kooky was his name. Kooky. And Kooky managed to muzzle the entire courtroom 9 times in under 3 minutes, including the judge. In fact, I have a little clip of that. Where did I put that clip? Oh, don't let me down now. Let's see. I've got it right here. You may have seen it. Here we go. Yesterday, I added a counter to this version. Here we go.
Yes, Your Honor. Sir, if you will, if you could, however the deputy handles this, but if you could retrieve the firearms from behind you.
Do it in public, and I will clarify that it is not loaded. Okay? First, it's a real.
Mr. Kuski, are you able to take the cylinder out so you can show everyone also that it's unloaded?
Yes, I can.
Okay.
That's something important. And here is a NX revolver.
So, Your Honor, I'm going to object.
All right, first of all, everybody's nervous because you have not demonstrated to us that they are unloaded. So before you start showing us the weapons, make sure they're unloaded, including that one that you just touched.
So at this point, he points the muzzle at his hand there. The court muted the audio, so there's a big one coming up. Right at the judge, and the bailiff reaches over to grab the gun. Oh my God. He points it at his hand again. Again, muzzles the courtroom. Now he's going to repeat it all with a second gun. Points it at his hand again. Hannah's coming into the courtroom, but I'll finish this clip up. Hannah's dressed in all black. That seems appropriate. He's made something out of a coat hanger there. He muzzles his own arm. Again. And again for the 9th time. And then we have this little clip here. This is a cross-examination of this dude by Carrie Morrissey. Here we go.
Do you agree that when you pulled that firearm out and pointed it in the direction of the judge, the deputy standing next to you had to intervene and grab the gun and point it down?
I don't object.
Everybody saw it. The jury saw it. And then he's going to say, I never pointed it at the judge. Oh, good Lord. I'm going to fast forward it. Here we go.
Mr. Kuski, have you ever been qualified as an expert in firearms safety in a court of law?
No.
Of course not. All right. Court's back at the big seal. Let's see. I'll prep it. So supposedly today, the defense has another couple of witnesses. I don't know where they can go from here. Really. Can it get worse? I'm not sure. And then the judge instructed the jury yesterday they should expect to have closing argument before lunch. So that would be nice. Last day of trial, and then we'll go on verdict watch. But while we're waiting for a verdict, I can finally stop watching this circus of a trial. I do it all for you, folks. I do it all for you. So while we're still waiting, of course, I'll mention that the sponsor of today's show is my good friends over at CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. They promise to pay their members legal defenses in criminal court and provide civil liability as well. And they do much more. They provide their members with an investigative team, experienced retired homicide detectives that fly in to the scene to be your investigators. So it's not that the only investigators are working for your enemies, the police and the prosecutor. Don West, Attorney Don West, one of George Zimmerman's defense attorneys, is their national trial counsel, consults on your case, world-class criminal defense attorney. There's other companies out there that purport to offer similar services. Some of them are just hot garbage, folks, and none of them are inexpensive. So don't waste your money. I've looked at all the companies offering these kinds of services. CCW Safe is the one I trust. I'm personally a member of CCW Safe. My wife, Emily, is personally a member. They're the best fit for me, and perhaps they're the best fit for you. If you'd like to hear exactly why I trust CCW Safe, you can point your browser to lawofselfdefense.com/trust, and I have a 2-3 minute video there explaining exactly why I chose them to have my back. lawofselfdefense.com/trust, and at that same URL, you can get a 10% discount code on your CCW Safe membership when you join me as a member there. Again, that's lawofselfdefense.com/trust. All right. Okay. Let's see. Let's take a look at the Law of Self-Defense chat. By the way, as always, when we take comments and questions, I'm pulling them from the Law of Self-Defense chat. Our members first, only after I've gone through all of them do I look at YouTube, and then I only look at YouTube super chats that are at least $10. The good news is it's dirt cheap to be a Law of Self-Defense member. It's only 99 cents, folks. 99 cents to be a Law of Self-Defense member, 2-week trial membership at lawofselfdefense.com/trial. And you get all your comments and questions answered for free instead of $10 a pop on YouTube. And after the 2-week trial, it's still dirt cheap. It's only about 30 cents a day, less than $10 a month to be a Law of Self-Defense member. For a month, get all your questions and comments addressed for less than $10, less than the cost of one super chat on YouTube. But at least check it out for the 2-week trial. That's only 99 cents at lawofselfdefense.com/trial, lawofselfdefense.com/trial. Though I did notice somebody apparently signed up and immediately went on to the member comments for the playback version of yesterday's show and chastised me for having a sense of humor. So if you're watching these live streams, folks, you know what you get if you become a member. If that's not what you're interested in, then, I'm not everybody's cup of tea. All right, let's see. Checking out the comments from the Law of Self-Defense members. By the way, in the member chat, those good folks spend a lot of time just chatting with each other. A good old time in there. Member Philip asks, Andrew, now that you've seen the prosecution's case, do you have any thoughts on how you would have constructed your defense case? Yes. Well, I mean, they're stuck with the facts their client gives them. It would have been nice if they had evidence of Hannah being, berated and screamed at and guns taken out of her hands and off her cart. But they don't have any of that. I mean, it's sometimes the client's just guilty and there's not much you have to work with. And these facts are really not ambiguous. Hannah had the gun. She's the armorer. She says she loaded it. Not Sarah Zachary, not anybody else. She loaded it moments before it went into the church. She hands it into the church as an obviously cold gun. Every gun on set is not supposed to have live ammo in it. She says she put dummies in it, so there's no blanks that are going to make a loud noise. She says she put 6 dummies in that gun, and she handed that into the church. Now, there's a little ambiguity about whether David Halls took it from her or Alec Baldwin took it from her, but it doesn't matter. The gun had a live round in it when she handed it into the church. Unless we're to believe David Halls, in the midst of all those people, pulled the hammer to half cock, opened up the loading gate, took a dummy out, reached in his pocket, put a live round in. It's just not credible. And for the mentally challenged people in the YouTube chat, no offense, YouTube, who were saying that once the gun left her possession, she has no more responsibility. That's what's wrong with you? It's like if she was dealing with nitroglycerin, and there's a safe way to pack it and a dangerous way to pack it, and she packages it the dangerous way, and then hands it off and says, "I packaged it the safe way," and then it blows somebody up. she lost responsibility for that package when it left her hands? Don't be ridiculous. You people are crazy. Crazy. All right. Yeah, it was always going to be a tough defense. I mean, it was really painful because of the the quality of this legal defense team. I mean, I'm sorry. This is the only case I've ever seen defense attorney Jason Bowles in, but I saw him in the interrogation sitting beside Hannah Gutierrez for 2+ hours, and he did nothing in there, and he's not doing much here. He's just not a good lawyer. I mean, listen, the facts for Alec Baldwin are no better than this, but I bet his defense attorneys are going to do a better job than we saw in this trial. I think they'll still lose on the legal merits, but I bet they do a better job. So just not good. Monica Barreras, I don't know anything about her either. Just she doesn't. Neither one of them presents as a top tier defense counsel, which is what you really need when the facts and the law are against you, like they are here. And Hannah Gutierrez didn't have that. Let's see. Member Zakuza says, I think the best defense would have been that Hannah was overworked and overpressured, but she spent what felt like a year telling the cops everything, which pretty much killed that line of defense. Yeah, we went over this in our interrogation yesterday, the second interrogation. It came up. Were people trying to pressure you to do more props work and less armor work? And she said, yeah, that could happen, but I have a strong personality, so I would just push back, and I wouldn't let that influence my armor duties. I mean, that's the only defense, and it's not a good defense because it doesn't excuse this level of irresponsibility. But that was it. And her defense attorney sat there at the interrogation table and let her answer that way. It's crazy. Member Kyle says that script supervisor, Mammy was her name, was phenomenal. Literally paid to pay attention to everybody and everything. Yeah, I thought she was great. I mean, listen, I wouldn't want to be stuck on a flight with her, but in terms of her witness value to the state, it was fantastic. Let's see. And that interrogation video was played for the jury. Now, what I don't remember, I think there have been opportunities here missed by Special Prosecutor Carrie Morrison, who is by far the best lawyer in this courtroom. Her partner, the other Special Prosecutor, Jason Lewis, appears a nice enough lawyer, better than the defense, but nothing close to the level of Carrie Morrissey. But I think Carrie Morrissey did miss some opportunities. That interrogation of Hannah Gutierrez was played for the jury. She should have paused right there and said because it was played while Detective Alexandra Fishlips Hooters Hancock was on the stand, who conducted the interrogation. She was lead. I don't remember Kara pausing right there and saying, did Hannah just tell us that if there were efforts to interfere with her armor duties, she would effectively push back because she has a strong personality? That would have been good to highlight to the jury. I don't remember that happening. And every time a witness on the stand was asked, did you feel the set was safe? And they all said yes. That was typically on cross-examination by the defense. Carrie should have come back on redirect and said, well, have you changed your mind about whether you think the set was safe now that we have a dead Halyna Hutchins? She didn't do that. Yeah, so the lead detective on the case, Detective Alexandra Hancock, who appears to have had a bad lip filler job done, during that second interrogation when Hannah Gutierrez, early on, she volunteers that before she was a police officer, she was a Hooters waitress. And that really got Attorney Jason Bowles' attention. He gave Alexander Hancock a second look after learning that. Let's see. Someone's asking about me looking at Florida. So I'm moving out of Colorado. Colorado's gone completely insane. But we're looking at 4 places. We're looking at Louisville, Kentucky, Huntsville, Alabama, Texas Hill Country around Fredericksburg, and Florida, probably the Orlando area. But I have to say, Texas Hill Country and Florida have fallen substantially in priority. So they're not quite off the list. We're still going to take a look, but they're less likely. So we're really focusing on Huntsville and Louisville. Yeah, either of those would be fine with me. Closing before lunch. Member Jeffrey says, closing before lunch, verdict in the afternoon. Yeah, maybe. Member Paul says, defense still has how many? 21 witnesses to call? Well, they had like 28 witnesses on their witness list, including Hannah Gutierrez' pseudo-dad, Thel Reed, the famous Hollywood armorer. But it's normal for each side to have a lengthy witness list and then call only a fraction of those people. Because when they make the witness list, they may not be sure yet if they want somebody, but if they don't notify the other side of the possibility, then they can be prohibited from calling that witness. So they tend to overlist, if that makes sense. The state did call almost everybody. I think they ended up with 35 witnesses testifying, and they only had 42 on their witness list. So like 95% of their witness list actually testified in court. That's pretty unusual. But the defense, yeah, they apparently told the judge they'll be done this morning with their witness testimony. I mean, yesterday was a train wreck. Let's see. Member David asked, wasn't the McFlaggy count video that I just played before, the kooky muzzling the courtroom, wasn't that with a Denix non-firing replica that's technically not a firearm? Well, Kooky says that the first revolver he was holding was Denix and the second one was real, and he flagged with both of them. But how do you know it's Denix? Because he says so? If he said, don't worry about it, it's unloaded, you can trust me, would you trust that? Of course not. Nobody would trust that. Am I supposed to trust that he picked the right one first? I mean, they operate identically. He said so himself. So how confident I am that he didn't pick up the real gun first? And he flagged with both of them. So let's see. I'm worried. Yeah, we're not looking at Tennessee. Nashville is too blue. It's like Atlanta in Georgia. It's just taken over the state. I don't want to have to move again in 5 years. Member Miles Dog says, Andrew, is it true you should never talk to the detectives? Yeah. I mean, there might be things at the scene you might want to say to police. Like, there's the guy's knife who attacked me, or there are witnesses who saw what happened. You want to get their statements. But once you've secured witnesses and evidence, there's no reason to talk to the police without your lawyer present, especially the detectives whose job is to be professional interrogators. They're trained on interrogation. That's not to knock them. That's their job. And you have no idea what words come out of your mouth could implicate you in a crime. You're just not sufficiently, you're too ignorant of what the legal conditions are. That's, again, not in a derogatory sense, in a technical sense. And they know exactly what they're looking for. Especially when they give you those Miranda waiver forms. Once you're Mirandized, you stop talking to anybody without your lawyer present, without your competent lawyer present, and maybe not even then. Maybe let your lawyer do the talking. You should definitely not have a 2.5-hour freewheeling interrogation with no guidance or structure imposed by your defense attorney sitting there at the table with you, who spent his whole time either taking notes on his yellow legal pad, Jason Bowles, or on his phone scrolling. Why is he taking notes? Doesn't he know everything that's going to be said by his client in that interrogation? Because he should. There should be no words that come out of Hannah Gutierrez's mouth in an interrogation that he's accompanying that he doesn't know what those words are going to be. There should be no note taking. I guess unless the detective says something he wants to make a note of, but nothing about his client. But he spent the whole 2 hours just scribbling when he wasn't chortling at Hooters Hancock. Will Parker asks, "Hey, Will, how you doing, man?" Will Parker, Freddie Merck's Gunworks up in the Kalispell area of Montana by Glacier National Park. I think I'm going to see Will later this year when I ride my motorcycle up there, hopefully, trial schedule permitting. Will Parker asks, "I'd like to know if the defense firearms expert had a Daubert hearing. If the prosecution knew he was a doofus, maybe they knew he would impeach himself as an expert and let it go." I don't see how he could survive a Daubert hearing. I mean, he has no formal training, no publications, no real experience other than being a hobbyist. But the defense had really screwed up. I think perhaps they had a qualified firearms expert they wanted to bring in, but they announced him so late to the state that the court agreed to not let him testify. So I think they had to settle for this guy. Maybe the court was sympathetic. Maybe the state talked to this guy and like, hell, he's likely to be as good a witness for us as he is for the defense. I mean, just in how he presents. And I know they had a meeting at the bench before he testified where the parties had agreed, the judge had ordered that his testimony would be very restricted to very specific areas. I don't know what the scope was, but when they did kind of a mini qualification, when he first took the witness stand, the judge asked if the state accepted this witness, and the state said, well, we will, within the constraints of what we've agreed to at bench. So let's see. Yeah. Member Kyle says, anytime you can start your cross-examination with, when you pointed your gun at the judge. Oh my God, that was awful. Remember, Lance says the REID 9 steps of interrogation. Yes, REID, R-E-I-D, is a formal school of interrogation techniques. You should Google it. It's really interesting because if you Google it and you read the techniques they use, they work on human psychology. I mean, they work on anybody. So anyone who thinks they're immune to interrogation, forget it. They don't need rubber hoses. They know how human psychology works. All right. So again, that's all the member comments so far. I'll just remind everybody that if you insist on putting a comment in YouTube that you'd like me to address, it needs to be a $10 minimum super chat. That's how that works. Still waiting for the court. I've got it up here on my screen. It's live. See if any super chats have come in yet. Candace sent a $5 super chat, but I'll read it anyway because I hadn't made the $10 announcement yet. Candace says, and thank you, Candace, for the $5. She says, just before you took SC of gun in palm, he pointed at judge. You need to screen capture that. Or oh yeah, I've done that. Obviously, you saw that now. So in the moment, I just did a quick screen capture of him muzzling the court. But now I have that whole video thing I did with the buzzers and the round count. And Soul Souffle says, 1999, how were old live rounds safely disposed of? Well, I can tell you, I'm not an ammo disposal expert, but I've disposed of quite a bit of ammo in my time. And there's a couple ways to do it. One is tedious, and the other is more efficient, but more dramatic. So the tedious way to do it would be to get a kinetic bullet puller, that hammer. See if I can. They never showed one in court. See if I can pull up an image. So here's what that looks like. What they've been talking about with this kinetic bullet puller. So this larger part here at the top, that unscrews. And there's what's called a collet, a metal collet underneath. And the metal collet, you can put a bullet in there and it grabs the case head of the bullet. And then you screw that plastic top back on to hold the case rigidly in place. and then you swing the hammer and you put the blunt end on the bottom against a hard surface, and the case stops with the hammer because it's trapped with the hammer, but the momentum of the bullet continues, and it may take a couple whacks, but the bullet will come out of the case. This is hollow on the inside, and the bullet drops down to the bottom, and of course the powder spins out of the case. So now you have a primed case, gunpowder, and a bullet. The bullet you can just throw away. It's inert lead usually. The powder you do have to be a little careful with, because you don't want to don't clean up gunpowder with a vacuum cleaner. You're making a bomb if you do that. But you could put it in a little tin and just take it outside and put it on a non-burnable surface and just light it with a match, and it just burns up. It doesn't explode. It literally combusts. And then you have the prime case. What do you do with the primer? Well, I've never tried to press a live primer out, but my practice was to spray a little bit of WD-40 in the case, and that was supposed to neutralize the primer. Now, I have to admit, I've never tried to fire a primer after I've done the WD-40 thing, so I don't know for a fact if that works. It never occurred to me to try it. But I would put some WD-40 in there, let it sit for a little bit, and then I would just throw the primed case in the trash. The other way to dispose of live ammo that you don't want, perhaps for some reason you think it's unsafe, so you don't want to give it to somebody to shoot, is you just get like a 55-gallon drum and put a bunch of paper and wood in there and start a little fire in the drum and just toss the ammo in there. And the ammo will cook off from the heat of the fire. Now, when that happens, the bullet doesn't go anywhere. When you fire a bullet from a gun, the bullet flies out really fast and the gun moves only a little bit because the gun is much heavier than the bullet. Well, when you just burn around outside of a chamber, just like in a 55-gallon drum fire, the bullet doesn't go anywhere. It's the heavier component of that arrangement. Now, the brass may go flying, but the prospects that it would fly out of the 55-gallon barrel, I mean, don't lean over the barrel, obviously, when you're cooking ammo off. But the prospects that piece of brass would hurt anybody I've never seen it happen. And I've seen a lot of ammo burned off that way. But if there's an expert on ammunition disposal in the chat who would like to comment, I'm always open to new suggestions. Why use a bullet puller that isn't pliers? Well, for one thing, you may want to reuse the case, or maybe even reuse the bullet. So, especially if it's a jacketed bullet, if you pop it out of the case, you can reseat it in a new cartridge. So, imagine you have a cartridge, and for some reason you think your press ran out of gunpowder, and you didn't notice, and you think, oh my gosh, I got 100 rounds here. I don't know if there's any gunpowder in there, and if there's no gunpowder, you could get a squib. So the primer has just enough power to push the bullet into the barrel, and it gets stuck in the barrel. And that's not good. That's a dangerous situation. If you fire another round after that, you could bulge the barrel. You could have a catastrophic failure of the firearm. So you don't want to shoot those rounds that you have reason to believe may not have gunpowder in them. So you may use a kinetic bullet puller to take the bullets out, see if there's powder. If there's no powder, you can reload those cases. You can probably reload the bullet. If you use pliers on the bullet, you're going to mangle it. Let's see. Reloading ammo doesn't make sense unless cost-wise. It doesn't make financial sense unless you do some kind of like specialty shooting, like really long-distance rifle, and you're crafting your own rounds for sub-second accuracy. And then you're making low quantities. You're probably using just like little individual station tools. Or if you're shooting like volume, like thousands of rounds a year, then it makes financial sense to get like a progressive, like a Dillon reloader. I use a Dillon 650 XL that has a case feeder, and it's got 6 stations. I forget. It's been a while. It pops out the old primer. It resizes the case. It bells the mouth when it adds the powder. It seats the bullet. It crimps the case, and you're doing that. Each of those separate actions for 5 or 6 different cases every time you crank the handle. So I think that's a great press. It's my favorite by far. But if you're only shooting a few hundred rounds a year, it doesn't, that Dillon 650, what does Dillon charge for that now? I think it was $400 or $500 when I bought it, but I didn't buy it with all the options, and I added the options over time. Let's see. They may not make the 650 anymore. They may have a newer model. It looks like now they call it the 750. It's, let's see, if I add, what can I add? If I add all the stuff, all the options, which would make it comparable to what I have, the machine cover, everything, it's let's see. Oh yeah. Oh my gosh, it's $1,500. So, I don't know what ammo costs in a store anymore. I don't need to buy ammo very often. And of course, the cost of reloading has also gone up, right? So when I was reloading actively, shooting 10,000 rounds a year in competition and practice, I could buy a box of 1,000 small pistol primers for $14.99. In fact, I still have boxes of 1,000 pistol primers labeled $14.99. I'm told that they're around $100 now. So the price of primers has gone up about tenfold. And I presume similar things have happened with powder and with bullets and with cases. So, of course, the cases are largely reusable, at least in 9mm and especially 45. I've reloaded 45 ACP brass until you couldn't read the head stamp anymore. It had been fired so often. 9mm is pretty good in that respect. 40 Smith & Wesson is a nightmare. Cannot recommend reloading 40 Smith & Wesson. I stopped shooting 40 Smith & Wesson because it was such a pain to reload. So $1,500 for this press. I'll pull it up here. This is the Dillon XL 750. I have the 650, the previous generation, but it looks largely the same. This looks just like my press at home, this image here. So $1,500 for this setup. And then there's other stuff you need. You need tumblers. You need the dies for whatever calibers you're doing. You need a micrometer. You need case gauges. Yeah, a whole bunch of stuff. Some tools to go with it for adjusting the press. Let's see. Yeah, 5th rule of gun safety: don't lean over the burn barrel if you're throwing rounds in there. Well, member Eric says, if you were on the witness stand, would you give that explanation of reloading tediously over the course of an hour, like the defense expert did? I think the defense wanted him to make it seem tedious and really difficult to do. It's really not, folks. You can do all this with basically one hand tool. I forget who makes the hand tool, but somebody makes it's a press. It only does one function at a time. You have to switch dies out, but you just it's almost like a big pair of pliers. You could throw it in a computer bag and travel with it. You could do it anywhere. Dillon's a great company, by the way. Whenever all machines break at some point, and there are some springs and small parts in this press, and occasionally one would break, and I would just call them and they'd send me a replacement for free. It was great. Yeah, those kinetic pullers are easy to use, these hammers. Unless you have like 300 rounds you screwed up, then it becomes pretty tedious. It would be helpful to have like a teenage child in the house to go through all that. But the reloading process it's not at all. I mean, like I say, I've loaded on my Dillon press well over 100,000 rounds. Let's see. Remember, Kyle says, I was reloading 40 Smith & Wesson for a while. Don't think I ever got the cost of the die set out of it before I quit. Yeah, it's just a pain. It's a pain. My big problem was it would develop these. Let's see if I can pull it up. Pull up some images. Pull up some images of ammo so I can give you an idea of the kind of problems I ran into. No, that's not what I wanted. Let's see. I'm trying to find a good image. That's not bad. So, oh, all right. So here's a picture of 40 Smith and Wesson round. And you can see, I don't know why it's doing that. You can see that at the case head here, it's smooth all the way down to the case head. But when you reload this, you have to squeeze a die over the top of the fired brass to resize it, because it expands in the gun. So you need to resize it down. And it would kind of push brass. It doesn't go all the way to the bottom of this case above the groove, because normally you don't need to resize that part. It's pretty thick there. But resizing the 40 would push brass down to the bottom of that. And it would, over 2-3 reloadings, it would push so much brass that it would look like a belted Magnum round. And a belted Magnum round is a round where they actually thicken that bottom portion of a round. And normally it's in rifle rounds, but you can see like there's a band here. It's to make the case head stronger for high power rounds. It's not supposed to happen in pistol ammo. And then when you get that band on the 40 Smith & Wesson, it won't chamber anymore because it's too thick to go into the chamber. So I'd load it 2 or 3 times and I'd have to start throwing brass away. And it was a real pain. Now later, I understand there was some company or companies that came out with special resizers that would resize the whole 40 brass to solve that problem. But it's another whole step. And it's a new machine, more money, another step in the reloading process. I just gave up on 40 Smith & Wesson. Not for me. Let's see. Member Jeffrey asks, has the defense just been trying to mitigate sentence at this point? And that's a good question, because on the legal merits, there's 2 questions that have to be answered, right? Guilty or not guilty? And then if she's guilty, what should the sentence be? So the maximum sentence is 18 months. And I believe the judge has complete discretion. Can sentence Hannah Gutierrez to anything from 0, maybe, just out on probation, supervised, unsupervised. David Halls pled guilty to the misdemeanor negligent handling of a firearm and got 6 months unsupervised probation back at home. So Hannah could get something like that. That's unlikely because David Halls took a deal. They didn't have to go through the trouble of prosecuting him. Hannah made them make the effort. You made the effort, you want something for that. But it could be 0. It's up to the judge, or up to 18 months. So on the legal merits, on the question of guilty or not guilty, I don't see how Hannah's not convicted on the legal merits. Now, juries are dangerous and unpredictable creatures. Anything can happen. They could simply decide they don't want to convict her. And that would be the verdict. But if they convict, and I don't see how a rational jury could not convict, most of what the defense has been talking about is not helpful to the legal merits on the question of guilt. It's irrelevant. But it might be relevant to the judge for sentencing purposes. She may consider it to be, Hannah was young. This was not a 40-year-old armorer with past military and police experience and has done 25 movies and has a reputation that he can stand on to push back against anyone trying to do something unsafe. The judge may take that into account and consider all those mitigating factors to reduce the sentence. Sure. And that would be important for the defense to do. Now, normally the defense would do all that after the verdict. So you'd have the guilt phase of the stage, and then you'd have the sentencing stage. And at the sentencing stage, there might be a pre-sentencing report prepared by investigators, and the defense would have the opportunity to introduce arguments about mitigation. Normally, you wouldn't do that. Normally, the whole trial, you're arguing for not guilty. You're not arguing for mitigation of sentence. But if you don't have not guilty to argue for, because the facts and the law aren't on your side, what do you talk about except the mitigation stuff? The trial has not started yet, folks. I have it up on another screen. It says it's live. So I'm just waiting on the court. Is that what I was referring to? The Lyman 310. Yeah, that's not the one I was thinking of. But of course that would work too. That one just looks like a pair of pliers. Let's see. This is the Lyman 310 reloading, and here are the dies that do the various functions. The pressing out of the old firing pin. That's what that needle-like thing is for. And they'll have resizing dies and belling dies and powder dies and crimping dies. You do one at a time on this kind of device. You'd screw the die in, adjust it properly, put the case in, and then just squeeze the pliers, and it would do that function. The press I was showing, the Dillon press, this one, is what's called a progressive press. So it has you can't really see it in this picture, but there's a round plate at the bottom, and the brass is fed from this blue bin at the top. It's fed down this tube, is inserted into the round plate, and every time you crank that handle, the round plate rotates to one of the different powders, one of the different die stations. So every time you crank the handle, you're raising that plate into the dies. There's 5 or 6 cases in it, and each case is undergoing the one specific function, but you're doing 5 functions with each crank of the handle, just on 5 different cases. Member Phillips says there's also the roll sizer that uses a unique method to resize cases to factory new specs, not cheap and a separate step. I think that's what I had in mind when I was talking about the 40 Smith & Wesson device that was on the market for correctly resizing those cases. It kind of resized them sideways instead of in an up and down manner. Court's awake because we had a couple minutes where we saw Hannah Gutierrez enter the courtroom. She's wearing all black today, all black, which seems fitting. I'll check out the super chats again. Okay. Yeah. All right. Let's see. This is what I was thinking of when I was talking about the hand press. The Lee hand loader. So it's different than the pliers one. You get a lot more leverage with this press, so that the handle, you hold it, you would squeeze it together, and or open it apart. When you open it, that piston goes down. The dies would slip into the top there. The case would go into the top of this piston, and then you'd squeeze it together, and it would push it up into the die. You get a lot more leverage with this. But you see how small it is. I mean, each of these, your hand goes on each side. It's not big, and it's only $73. And that's literally, once you have the dies, that's all you need to reload, pretty much. And you can just carry that in your gun bag. I mean, you could go on an extended elk hunting trip in Colorado or Africa or something and reload ammo without the $1,500 Dillon press. It would be a lot slower, of course, but if you're reloading rifle ammo for a hunt, you're not shooting in quantity, probably. Jeffrey says, I really should get into reloading. Between all the guns, I've gone through a case of 9mm and a case of 5.56 in a month more often than I want to think. Yeah, if you're shooting a case, so I presume you mean 1,000 rounds a month, it's almost certainly worthwhile getting a reloading press if you plan to continue doing that. And the my Dillon XL650 will reload 5.56. I've reloaded 30-06 on it. I will say reloading rifle brass is more complicated, especially rifle brass with a shoulder on it, which most modern rifle brass has. Because when you fire rifle brass, it doesn't just expand sideways and need to be resized like a pistol cartridge. It expands lengthwise. So it needs to be trimmed, which is another step. And Dillon does sell a motorized electric case trimmer that you can install in the 650. I never use one because I don't reload enough rifle ammo for that. When I reloaded 30-06, I only reloaded a few hundred rounds, and I had a little hand operated machine I could use to trim the case back. Eric asks, how are you liking those Shure headphones? So I got new earbuds. I don't know. They're way better. I mean, the sound quality is way better than the $100 ones I was using before. But they were expensive. They were several $100s. So I'm hoping they're more robust. My $100 ones would last a year and then they would break. So over 4 or 5 years, it's the same cost if these will last. The sound quality is definitely better. Member David says, buying the components these days is almost as expensive as buying factory new on sale. Well, fair enough. I haven't done the price comparison. When I started reloading in the 1990s, quite a while ago, I think there was something like reloading your own was about 20% the cost of buying factory new ammo. And so you just do the math. How many rounds do I think I'll be reloading? That's what I'll save. How much does the press cost? So what's the break-even point? And the break-even point for me was like a year out. And I've had that press 30 years. So it's, paid for itself many times over. But the economics may well be different today. Let's see. But yeah, reloading was great. I would mostly reload over the winter. I was in New England, so there wasn't a lot of shooting happening in the winter. And you just load thousands of rounds. You're like your summer supply. And then whenever you go to shoot a match or go to practice in the summer, you just reach into the 5-gallon bucket full of 45 ACP, scoop out a few handfuls, put them in your ammo bag, and head off to the range. When I first started reloading, I would buy the hard plastic like MTM cases with the little square for each round. I gave up on that pretty quick. When you're shooting 1,000 rounds a month, you don't keep those cases very long. The only thing those cases were really helpful for was when I was working up a load. So I wasn't sure how much powder and what bullet weight I wanted. So I would do a bunch of variations and I would take them to the range and I would chronograph them. I would check how the velocity of the rounds. And then I would adjust the powder or the bullet weight for what I was looking for. Let's see. But once you have a load set up for once you've got the formula you want, the powder and the bullet weight you want, I've been reloading the same 45 ACP, 200 grains on my wad cutter. I think it's 4.3 grains of unique. I'd have to check. I reloaded that same formula for 20, 25 years. So it just ran in the gun. That's for 45 ACP. I don't remember what it was for 9mm. I have it taped on a piece of paper on my press, but it's been a while. Let's see. Member DJ says, if you're a precision long-range rifle shooter, loading your own still makes sense, even if it is more expensive than off the shelf. If you can load better than factory, sure, yeah, because you're not shooting in volume. So the priority there is the accuracy at distance. Member David says, you've mentioned intervening cause as a defense. What evidence or witnesses and line of questioning would you have used to argue this defense? They should have argued it already. The defense should have argued it when they were doing cross-examination of the state's witnesses who were in the tent. They should have been eliciting evidence, more explicit. It wasn't Hannah Gutierrez who was holding the gun when it discharged, right? It was Alec Baldwin. Was Alec Baldwin supposed to be pointing the gun at another person? To your knowledge, based on what you know of SAG rules, were you surprised that happened? Was that unforeseeable? And then, hope you get the answers you need. And then when you get to closing, you weave that all together into an intervening cause argument. If you can get an intervening cause instruction from the judge, the judge might rule as a matter of law, it doesn't apply here. Yeah, I mentioned the gunpowder unique before. It might have been tight group. I can't remember now which I finally settled on. I used both for sure. I meant to check when I got home, but I forgot. Let's see. If you go the Dillon, I think Dillon is probably the most expensive reloading equipment, I would think, compared to RCBS and some of the other companies. I think it's the best. But there are much less expensive ways to go. It doesn't have to cost a ton of money. What you're getting for the money is throughput, is quantity. How many rounds you can effectively reload in, say, an hour. On my Dillon XL650, I could do somewhere between 300 and 600 rounds an hour, which is pretty good. So I was shooting 1,000 rounds a month. So, in a weekend of reloading, I could reload, really, if I did it for the whole weekend, all the ammo I needed for a year, if I had all the components on hand. But I would buy powder in 8-pound jugs and bullets by 500, 1,000 at a time. Primers, of course, you just buy 1,000 at a time in the box of 1,000. And I had a lot of primer tubes for my Dillon press. I had 10 or 15 primer tubes, and when I started reloading, those were all full already. So that didn't slow me down. Yeah, if you have someone who will trust you, it's not if you can split the cost of the press. So you have two shooters shooting 1,000 rounds a month, and you buy one press, because again, you don't need the press continuously. In one weekend, you could probably reload all the ammo you need for a year. So why not share the press with somebody? But you have to trust them. It might have been tight group. Yeah, it really rings a bell. The powder I was using. I would reload a whole ton of 45 ACP on my XL650, and then I would change out. They have what are called conversion kits that make it relatively straightforward to switch between 45 ACP and 9mm. You keep the gauges set the way you had them, so you don't have to reset the gauges when you make the switch. So I'd load thousands of 45 ACP and then thousands of 9mm. It was very straightforward. Let's see. Member Nathan asks, are there red flags, green flags on if someone is a competent attorney when trying to find one to hire? That's one of the things we do for our platinum members is, of course, I interact with their attorney. So I can effectively vet their attorney. I'm doing a legal consult for a platinum member right now. In fact, I just got the discovery file last night. And I've been talking to his lead counsel on the phone, and the guy strikes me as a intelligent, sharp, a good lawyer, diligent, cooperative with me. Sometimes the lawyers, sometimes they feel like there's, if I bring this Andrew Branca guy in, is he going to be a problem for me? Like, are there too many cooks in the kitchen? Not getting that vibe from this guy at all. So it's all good. If I were talking to Jason Bowles, my first concern would be he just doesn't present like he's bright. And then when I see him functioning as an attorney, like in the interrogation, he just doesn't function like an attorney. He's not doing what one would expect an attorney to do when sitting next to his client in interrogation. So I would have real concerns about that. But I'm not sure how a layperson would know that. I'm not sure how Hannah Gutierrez would know. Most lay people wouldn't know what to look for. So it's really one of the values we add for our platinum members is they know their defense attorney is going to be vetted, at least implicitly, by me when I'm dealing with that attorney. Member Chris asks, how does this all look for Alec in the fall? So Alec, actually the summer. Alec's supposed to go to trial August 6th. It looks bad for him. And there's nothing that I heard in this trial that changes my mind. Again, the legal question here is very simple. Was there a live round in the gun when Hannah Gutierrez handed it into the church as a cold gun? And the answer is yes. Unless you believe David Halls or Alec Baldwin put the hammer at a half cock, opened the loading gate, took out a dummy, reached in her pocket, put a live round in. I don't think anybody believes that. So it seems incontestable. The only reasonable inference from the evidence is that Hannah handed into the church a cold gun that had a live round in it. That's reckless manslaughter right there. So very straightforward legal question, and the evidence is all on one side of the question. The same is true for Alec Baldwin. What's the legal question? Did he point what he knew to be a real gun at Halyna Hutchins without ensuring there was no live ammo in the gun? And did that gun then kill her? Yes. Now he'll say, I didn't press the trigger. I don't think anyone believes that anymore. We heard this Luke Hague will be back for this state when they're prosecuting Baldwin. The gun doesn't fire unless the hammer is fully cocked and the trigger is pressed. That's just manslaughter. You point a gun, what you know to be. Now, what would have saved Alec Baldwin is if he'd kept his mouth shut, insisted on a lawyer for his interrogation, because as we know now, there was an exact duplicate of his real gun that was a Denix replica. Looked the same, functioned the same, except it could not fire a real bullet. And if in that church, Alec Baldwin, the gun goes off, and Alec Baldwin's like, holy crap, I thought this was the Denix gun. I had no idea this was a real gun that could fire an actual round. That would have cleared him of all liability. But instead, in his interrogation, he tells Detective Alexandra Fishlips Hooters Hancock that these are live guns. He knows they're real guns. These are real guns. And there goes his defense. If he had a lawyer with him, a competent lawyer with him, his lawyer would never have let him say that. Never. So he talked his defense away. His only viable defense he talked away. So no, Baldwin's in a lot of trouble. Again, juries can do anything. So that's why I don't predict verdicts, because juries are unpredictable. But I do legal analysis, and on the legal merits, all the weight's on the side of the prosecution, all of it. Well, I don't know if we're going to do closing this morning, if this is going to keep going on. Let's see. Take a look. Member Cycle Boy says, if Baldwin was drawing and cocking, he'd have to press the trigger to decock. Yeah, a good point, right? So there's no way he was going through repetitive cycles of drawing and cocking the hammer without touching the trigger. Once he gets that trigger to the quarter notch, to the safety notch, to get it down again, he has to press the trigger to release the hammer. Member Kent says, I didn't hear Hannah's interrogation. What did she say that she thought would exonerate her? She was a lot of smoke and mirror stuff, that she was had to divide her attention between props and armor, that she didn't know where the bullet came from. Could have come from this place, could have come from that place. A mystery box of ammo appeared in the prop truck. She has no idea where that came from. She thought maybe it was a dummy with a live primer that made the noise. Of course, that doesn't explain the bullet. But she didn't have anything that was relevant to the question of, did she hand into the church a purportedly cold gun that had a live round in it? There's nothing that can test that. No evidence in this trial can test that question. And that's the only legal question here for her prosecution. Let's see. And frankly, the detectives were not very sharp. So, this is the Santa Fe Sheriff's Office. They got like 30 deputies there. It's not a big department. They're not likely to be very experienced. Certainly, the New Mexico law enforcement who investigated the Dean Cummings shooting, which we covered that trial too, were terrible. But in these interrogations, it's clear Detective Hancock didn't really understand the difference between live rounds, dummies and the various types of dummies, blanks and the various types of blanks. They kept using the term ammo to refer to blanks and dummies. It's a lack of clarity in terminology that reflects poor understanding of what they're actually talking about. And I'm not sure the detectives in those interrogations knew what the correct legal question was, so they didn't focus on it. They were asking a lot about where the round could have come from. Where the round came from is completely irrelevant to the question of, did Hannah Gutierrez hand into the church a purportedly cold gun that had a live round in it? It doesn't matter where the live round came from. It doesn't even matter who put it in the gun, although Hannah says she put everything into the gun. So she would have put the live round in too. There was they spent hours talking about stuff that really didn't matter. And Kerry Morrissey has done that too, because although a lot of this stuff is smoke and mirrors, you don't want the jury to be misled by the smoke and mirrors. So stuff like the live rounds from the set of Yellowstone 1883 were different in shape and appearance than the live rounds found on the set of Rust. I mean, it doesn't really matter if they were the same. It doesn't matter if the rounds came from Yellowstone 1883. If the round that killed Halyna Hutchins came from 1883, if the other live rounds found on the set of Rust came from 1883, so what? They still should not have been in the gun that Halyna Hutchins handed into that church. It doesn't matter. Philip says Hannah can still plead guilty and throw herself on the mercy of the court. I mean, that's not going to happen. She might get lucky. Need one juror to be undecided, to believe guilt has not been proven beyond a reasonable doubt. One, and it would be, I would speculate that it would be a female juror leaning more towards the emotional side of the cognitive spectrum and not the rational side, might feel sympathy for Hannah. For all these factors the defense talked about. She's young. She was the least powerful person on the set. We're going to hear all this in closing again, just like they talked about it in their opening statement. In fact, during the verdict watch, I don't know if I should bother going over the opening statements again. I did a whole show on it a week or so ago on one of the weekends. But you might get a hung jury. Who knows? And then it's up to the prosecution if they want to go through all this again. They might. Or maybe she'll get a hung jury and the plea negotiations will open up again. But at this point, going into closing argument, there's no sense throwing yourself on the mercy of the court. Let's see. Member Phillips says Alec Baldwin is the world's greatest actor per Team America. What a great movie that is. Team America. Making my lunch arrangements. Member Chris says Hannah seems smug the entire trial. Well, it's always awkward because as the defendant, you really want to keep your expression stone-faced. You don't want to show any emotion. Whatever emotion you show is likely to be perceived negatively by one or more jurors. So The defendants are told to keep no expression on their face. On the other hand, even during the interrogations, Hannah seemed distraught, upset about her own circumstances, like my career, criminal liability for me, but not so much for Hannah. And Carrie Morrissey has talked about that with some of the witnesses, and she'll talk about it. I guarantee you she'll talk about it on closing. And I don't know if Hannah's planning to take the stand. She could. It's up to her. If she takes the stand, she better be crying about the death of Halyna Hutchins on the witness stand. Jeffrey asks, this is a hung jury and retried after the Alec conviction, if presuming we get an Alec conviction, does that change anything to help her? I mean, not in terms of the legal merits, that doesn't change, but in terms of the dynamics of the prosecutor and the defense, I mean, I presume Hannah would get a better lawyer. I hope she's been watching. Someone would alert her to the fact that she ought to change counsel. That would be helpful if she has the opportunity at a second trial. The prosecution may reopen plea negotiations. You know, circumstances are different now. They may be satisfied if they get an Alec Baldwin conviction, that they don't need to go as hard after Hannah. Maybe they'll have her plea to a felony, but no time served, and the felony would keep her from ever handling firearms again. So let's see how we're doing here. 1,000 people. Is that possible? 1,000 people watching on YouTube and 217 thumbs ups. Come on, folks. You can do better than that. You can do better than that. Now, I think it's possible. I've been told that a lot of you, statistically, half of you on YouTube are watching on mobile devices. And if that's the case, you may not have the ability to subscribe or hit the thumbs like up until you exit. If you could do that when you exit, that would be greatly appreciated. Hey, Moto Jitsu, Greg Woodmar in the chat. Moto Jitsu, definitely. If you ride a motorcycle and you don't follow Moto Jitsu on YouTube, you are absolutely crazy. That guy is a wizard on a motorcycle, and he doesn't just make it up, folks. He tests everything empirically. He goes out and rides with the left hand, with the right hand, with the front brake, with the back brake, changing body position, not changing body position. He does not using brakes at all in some of those curvy mountain roads, just using engine braking and throttle. And he tests everything. You can take what he says to the bank. Great stuff. He makes riding a motorcycle, if you do what he says and, as he says, shut up and practice, actually practice, he makes you a much safer rider. He's made me a much safer rider for sure. That's Moto, M-O-T-O Jitsu, Moto Jitsu on YouTube. He's got a bunch of books too. You should take a look at those. I've got all of them. Let's see. Yeah, remember Eric says David Halls, when he testified, had the kind of emotional response you would expect, and so did Joel Souza. Yeah, I think that's right. Yep. They were David Halls clearly emotionally accepted responsibility for his failure here. He should have checked the gun too, and he didn't. So Halyna's death is partly his fault, and he said on the stand, that's why I took that plea deal, misdemeanor conviction for negligent handling of a firearm. That was a pretty good deal for him. 6 months unsupervised probation. It's all over now. But he's got that conviction on his record. And of course, the moral burden of knowing he contributed to the death of a woman, a wife and mother, who by all accounts was wonderful. Law self-defense, David says, I honestly believe everyone on set was so completely shocked that a live bullet was fired that their minds couldn't get around that possibility. Yeah, that was apparent to me too. They simply couldn't mentally accept that there was any possibility that a live round had been fired. That's how impossible, because you have to keep in mind, Guns are used on TV and movie sets thousands, millions of times a year. And no one's ever shot. I mean, they have gun fatalities half a dozen times in 100 years of filming. And so it is unimaginable. They're using real guns on set all the time. And no one ever gets shot with a live round until it happens. And it happened because Hannah Gutierrez failed. In her most important job responsibility was to keep live rounds out of the gun she's handing onto the set. Let's see. Joe asked, do you think Hannah will testify in the Baldwin case? I don't know. I wonder if the Baldwin defense could compel her to testify. They might be able to compel her to testify. I mean, if she's acquitted here, then she's clear of legal liability. So the reason to refuse to testify would be your Fifth Amendment right not to incriminate yourself. But if she's acquitted, she's clear of legal liability here. So she couldn't incriminate herself. If she's convicted, she's sentenced, well, then that's over too. I mean, there's no additional charges she's facing or could be facing. So there's no incrimination possibility. So I think, yeah, they might be able to compel her. Now, if it's a hung jury and she's facing retrial, then she definitely has a Fifth Amendment privilege not to testify. But otherwise, yeah, the court may allow the defense to subpoena her, and she'd have to testify. She would testify that she only put dummies in, and then she'd have to explain where the live round, how come there was a live round in the gun, and that would be the kind of smoke and mirrors on the Baldwin side that they're trying to do here, right? Which is deflect all the blame to the extent possible from Baldwin. Still waiting on court, folks. Still waiting. It's been going on for an hour. Would it hurt her on appeal? Yeah, that's a fair argument if she's appealing. But the sentence is only 18 months. She's not going to get an appeal heard in 18 months. So, by the time the appeal came up, her sentence is over. So why are you spending the money to appeal? You're not getting out of prison. You're already out of prison. For your reputation. But remember, the prospects of meaningful relief on appeal are less than 1%. And that relief, the best relief you typically get is a new trial. So she goes through the whole trial again? Maybe. I mean, part of that, of course, is also the sentence. So if she gets 18 months, which is the max, she may appeal and say, well, maybe if I do a retrial, what's the worst that can happen? It's this, 18 months. Maybe I get a better sentence on a retrial. Maybe I get acquitted on a retrial. In the Kim Potter trial, the taser trial, the trial judge was kind of clever in that she sentenced Kim Potter to only about effectively 14 months in prison, which would be over long before any appeal was heard. But Kim Potter, if I remember correctly, she was looking at 20 years maximum. So if you're Kim Potter and you got a sentence of 14 months, do you appeal? For what? A retrial where you could get sentenced to 20 years? I think you just do the 14 months, which of course is what Kim Potter did. And she has since been released. And I don't expect has any intention of appealing. Let's see. Oh. Let's see. What can I play that would be helpful? We could just listen to Kooky the expert from yesterday. Let's see. Maybe I'll do a poll. And I'll do a poll on YouTube, and then I'll just ask you guys in the member chat How about this? We could restart the Kooky testimony from yesterday. It's not very long. In fact, I think I have. Let's see. I carved it out yesterday for the playback version of yesterday's show. It's the direct was 40 minutes. And the cross was only 11 minutes. And then there was like a 2-minute redirect. All right, so let me see. We could do the Hannah's first interrogation with Detective Alexandra, Fish Lips, Hooters, Hancock. Or we could do gun expert Kooky. Or I'll just add other, and then I'll have to pick something else. All right. So while we're waiting for court, and you folks in the Law Self-Defense chat, let me know. Hannah's first interrogation, or the Kooky testimony, or something else. Because, of course, I know people pop in and out. Not everyone got to see the Kooky testimony. Let's see. Kooky. The members are all Kooky. And the survey is, well, Kookie's in the has the plurality at 47%. Other is 37%. Hannah's first interrogation is 17%. Kooky, the investment flagger. All right, so it's for some reason it's just spinning now. I guess I got to reload that. Let's see. Okay, let's see. All right, so this is yesterday's testimony of Frank Kooky. See if I have a banner for him. And starting from the beginning of his testimony. Here we go. There he is. Someone said that was a Ukraine support tie. I don't know if that's true or not.
Do you swear or affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
All right, have a seat talking to the microphone. Thank you.
Okay, sir, good afternoon. Can you please tell the jury your name again?
Frank Lewis Blair Kuski III,
4 names.
Where do you
Third.
currently reside?
Carmel Valley, California.
And what do you do for a living, sir?
I'm managing director of Blair Financial Group, Money Managers.
Money
I
man.
want you, outside of your management and Blair Financial, to tell the jury about your experience with period firearms.
Yes,
I'm a big
prior
deal.
to, let me check the note to make sure dates are correct. I took part in,
So this accounting of his purported background and expertise is amazing. He talks about shooting rifles when he was 6 years old and being in the Boy Scouts. Those are among his qualifications, and being a reenactor.
in my first movies in this, which were done with,
And I'm not
He used to go shooting with his uncle and his grandfather, hunting with his uncle and grandfather. Those are part of his qualifications.
talking about the movies. Let me just,
I'm sorry, okay.
yeah, let me just try to center my question. Yeah.
I'm still checking.
Okay.
So objection. There's quite a bit of this. I'll fast forward. I'll skip forward past some of that stuff.
Kuski, if I can just direct that a little more, I want to go just give the jury an overview of your experience with firearms, and not necessarily getting into movies yet, but your experience with firearms and period firearms and how you obtain that familiarity.
Do you wish for the long explanation or the short?
No, the short.
All
Short's
right.
always better.
My father was a combat MP in the Second World War. I was shooting almost from birth. I was sent to rifle camp in Butte, Montana at age 6, which is hard to imagine. I grew up around a hunting family. My grandfather was a big time hunter. I grew up hunting deer and pheasants with my uncle in the forests of Ohio. I had Ohio and Indiana and Pennsylvania hunting licenses ever since they were required. I was a member, I was a Boy Scout Riflery Merit Badge winner. I worked, was a member of the Kenyon College of Rifle team. Following graduation from Kenyon College, I took up firearms in a very serious way, beginning collecting and shooting. I was trained by Louis Tenenbaum, essentially right out of college, who was a member of the U.S. Army Marksmanship Unit, who thought I was worth taking his time with that. I appeared in a number of little television shorts and things like that through that time period. And when I really got going on primitive firearms, and I won't even talk about self-defensive guns at this point, I was trained in combat guns. I first appeared in the George Washington television miniseries in 1984, and I was assigned my role as a surveyor in the wilderness. And of course, I had my first real flintlock in my hands at that time. I, during the earlier times, had shot a lot of primitive weapons, primarily flintlocks, black powder stuff. Was very interested in that. After that, I got going and I joined a group called the
It's important to keep in mind, folks, that as ridiculous as many of us will perceive this narration of quote unquote expertise, this guy believes all this makes him a big deal in this space. He believes these are genuine qualifications.
First American Regiment in 1985, which was the premier late 18th century, early 19th century reenactors for military reenactment. And during this time, and I believe you have a nice picture of me firing cannons, I became...
Yeah, it's I mentioned Greg Widmar earlier. He was in the chat on YouTube, the motorcycle guy. Think the world of Greg. But he remarks all the time that he meets people frequently who say that I don't need to learn anything new about motorcycling. I've been riding for 20 years. I've been riding for 30 years. And yeah, and they've been making the same mistakes for 20 or 30 years. So time doesn't tell you anything about a person's actual qualifications. These people riding for 30 years are no better in year 30 than they were in year 1 because they're just doing the same stupid stuff over and over again. And they're just lucky they haven't had a crash. Just like on the movie set of Rust, that shooting of Halyna Hutchins could have happened on the first day of filming. But whatever the first day was, that guns were brought out. It didn't happen because the safety rules are redundant. So more than one problem has to occur in order for a bad outcome to happen. But it could have happened at any time.
Became a sergeant of artillery doing reenactment big time. And in that capacity, I appeared in lots of movies. I fired artillery. This is 18th century artillery. I fired the 1812 overture with Cincinnati Symphony in various performances in big stadiums and things. I also, sorry for the cough. I also answered questions for NBC Nightline fairly routinely on weapons identification, because of course I'm fairly good expert in Russian weapons and one of the largest collectors in the United States. I took part with First American Regiment in many, many, many different film productions, television productions, that sort of thing, which were done by PBS and I believe the History Network. These were shown at the time on television and also became educational movies, programs. They sold the rights to us, charging with bayonets to all kinds of ad agencies.
Okay, let me stop you for a second,
Yeah.
because there's a lot of information. And,
Well, I'm sorry.
No, that's okay. But I want to ask you, in the course of that, and you've had a whole lifetime, is that fair to say?
Yes, it is.
Of gun. Have you been a collector also of period type weapons?
Yes, very much so.
Okay. Are you familiar with the revolver in this case, the 45 long Colt?
Absolutely.
Did you bring with you today that revolver? Not that revolver, but a revolver just like that revolver?
Yes, we would call that a sister. It is made by Pieta, the same exact company, with nearly sequential serial numbers. It is absolutely identical. Any part would interchange.
Someone in the chat asked what motorcycle I ride. I ride a BMW, I think it's a 2020 R1250 GS Adventure. And let's see if I can pull it up quick. I've got a picture here someplace. I took on one of the mountain passes here in Colorado. It looks just like, it doesn't look just like, this is the bike. This is the actual bike. So that's it. That's my motorcycle. Usually I have panniers on it, side cases on it, and a top case. I must have taken this picture right after I bought the bike and didn't have the cases yet.
First of all, what that is?
This is nearly sequential serial numbers. It is absolutely identical. Any part would interchange, and it will look exactly like the Baldwin gun.
Did you also bring a replica gun with you?
Yes, I did.
And can you tell the jury just, first of all, what
Sure.
that is?
This is a Denex replica. Denex is a company in Spain that makes replicas of anything from shotguns to antique weapons to swords, things like that. They're used by reenactors. They're used in movies. There was a Denex revolver on the set of Rust that was used as one of the dummy guns. There were, in fact, 10 non-firing replica guns on the set that looked like this. So it can't shoot, but it looks like it. It functions, it cocks, the cylinder turns, and from 5 feet away, you couldn't tell unless you really looked.
Okay, sir. Let me, if I can.
I don't remember what the motorcycle cost. It was expensive, though. It's probably among it's a very expensive motorcycle.
Yes, I was going to ask at this time, Your Honor, if I could tender him as an expert in the categories I previously did.
Well, why don't you state them on the record again?
I was making sure I had the exact wording. Is that okay if you wrote those down? Because I don't want to change it. Well, I'll just say it again.
Yes, this is the defense firearms expert testimony from yesterday, folks. Court hasn't started up yet today. Like it says at the top there, day 9. Today's day 10.
It's firearm identification, firearm functioning, reloading of ammunition, and identification of ammunition, of dummy rounds and live rounds.
Now we're having lots of motorcycle questions. I have ridden the tail of the dragon. I did it once just because it's a bucket list item. It tends to get a little too crowded for my taste, and there's a lot of law enforcement. and the posted speed limit's pretty slow. If I recall, it's 35 miles an hour. There are lots of other nice roads in that area that are not the tail of the dragon that I would prefer to write on. The tires, I don't go off-road anymore, so I just put Michelin Road 6 tires on it. Those are like long-distance touring tires. You'd find them on a Goldwing, any long-distance touring motorcycle. They're great. They're sticky as F. They're very confidence-inspiring.
Any objection?
No objection within the confines of what we discussed at the bench.
All right, thank you.
Yes, I understand. So, sir, if you will, I'm sorry.
For these specific areas, subject to the ruling up at the bench. Thank you.
Yes, Your Honor. Sir, if you will, if you could, however the deputy handles this, but if you could retrieve the firearms from behind you.
And this is where things begin to go
I
sideways.
will clarify that it is not loaded. Okay? The first is a real.
Mr. Kuski, are you able to take the cylinder out so you can show everyone also that it's unloaded?
Yes, I can.
Okay.
Something important. And here is a Genex revolver.
So, Your Honor, I'm going to object.
Going to object. Here's where things go bad.
All right, first of all, everybody's nervous because you have not demonstrated to us that they are unloaded. So before you start showing us the weapons, make sure they're unloaded, including that one that you just touched.
Now, the court has muted the audio here. So that's not me. Points are right at the judge. And look at the expression on Carrie Morrissey's face. She's like, oh my God, did that just happen? The audio is muted because the lawyers are at bench. This guy doesn't know he's not supposed to be testifying. He's actually he's talking to the jury and to the bailiff here. He never had to point the muzzle up in the air before showing the gun was clear. And I don't know what this court building looks like, but there's plenty of court buildings where the courtroom's like on one floor of a taller building. So there's people upstairs. He could have taken it out of the bag, kept the muzzle pointed down the whole time, shown the bailiff that the chambers were empty, pulled the pin, taken the cylinder out without pointing the muzzle in any direction but down. No, he wasn't allowed to just carry these into the courtroom. These would have been put in bailiff custody when he got to the courthouse. I do like his wire, his coat hanger wire. he didn't buy like a professional obstruction in the barrel checking tool. On YouTube, someone says, court TV lady said people in court ducked. Yeah, I would have ducked. I would have ducked. You point a muzzle at me, I would have yelled. So remember, folks, I read comments and questions from our Law Self-Defense members on the member chat. Get a 2-week trial membership for just 99 cents at lawselfdefense.com/trial, or as a $10 super chat on
Okay, Chrissy, I want to make sure that, one, first of all, the Denix is the replica, that's non-firing. That is obviously clear, it cannot fire, correct?
Yes, I wish to demonstrate. that
Okay,
you
but
can-
and just let me lead the questions.
Sure.
The other Pieta, you cleared with the deputy, but I want you.
This witness is all about this witness. He's there to self-aggrandize himself. I guarantee you, after all that muzzling, when he got back to his buddies at the gun range or the little local gun store or the saloon where he hangs out in California, he bragged and bragged and bragged about how awesome he was as an expert witness on guns in a courtroom. First time he's ever had this opportunity, and he knocked it out of the park.
To be able to take that cylinder out so we can show everyone is clear. Is that?
Absolutely.
Okay.
Gun is pointing in a safe direction. Now, if we can get this pin out, the cylinder is retained. Cylinder is retained by a pin. Once that pin is removed, the gun may be put in a partially cocked position. The cylinder may be pushed out, and again, the barrel's safe. You can look right straight through it. Sir, would you take that and show them all? It's empty. Is that acceptable?
It's up to the court.
Yes.
Okay.
No, the
No.
deputy is not involved in this.
okay.
Okay. And so,
It is empty. I demonstrated it's empty.
okay. Okay.
May I return it to the
Yes.
firearm?
The deputy's not involved in this. Up. Something's happening. We are live now in court. Let me change that banner. Let's see
All
what
right,
we
you may
got.
be seated. Good morning, jurors. Thank you so much for your patience. All right, next witness.
Your Honor, we call PJ Pesce.
We do have a witness.
Do you swear affirm under penalty of law that the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
All right, have a seat, talk into the microphone. Thank you.
I don't see this guy on the witness list.
Good morning, sir. And you please tell the jury your full name.
It's Paul Peter Pesce Jr., but I've always been referred to as PJ Pesce.
Mr. Pesce, what do you do for a living?
I direct and write movies and television.
How long have you been in the business of directing and writing movies and television?
35 years.
Can you give the jury a background on your movies that you've directed and kind of a biographical sketch?
Sure. I attended Columbia University and studied under Martin Scorsese and did a short film that traveled around the world. I wound up getting a deal at Paramount in 1990. I directed a film for Roger Corman in 1991 that I wrote and directed. In 1995, I directed a Western with Sam Elliott that we actually shot at Bonanza Creek Ranch. That was a also rather lower budgeted short schedule. I've directed 6 feature films and close to 100 hours of television. I've created television shows. written and sold movie scripts. I've worked for Paramount, Warner Brothers, HBO, Universal, Fox. Anything else?
That's a really good background, and I just want to ask you with regard to the Western on Bonanza Creek. That's also the site of where Rust was filmed. Is that right?
That's what I understand.
Well, Mr. Pesce, it sounds like you have experience also with movies involving firearms.
Yes. Many of the television shows, and I think 4 or 5 of the 6 films, 2 of them were Westerns. One of them was one of the Sniper series with Tom Berenger. One of them was Smokin' Aces, which had a considerable amount of gunfire.
In your work on the movies involving gunfire, have you had the occasion to work with armorers and prop masters?
I have.
And actually, in all of the movies you've done, I'm certain you've worked with prop masters.
Yes.
Okay, sir. And with regard to those movies that you've directed in television, have you worked with directors, first assistant directors, and understood people's roles on the set?
I have.
Okay. With regard to armorers, have you ever worked on a prior film in which an armorer had split duties as an armorer and a props?
I have not.
With regard to this situation where there is a gun-heavy set I will represent to you, would you think, in your experience and what you've seen, it would be advisable to have a part-time armorer doing 2 jobs?
I would say that would be highly inadvisable.
Whose responsibility is it to properly staff with regard to the movie functions?
The line producer or the unit production manager.
When you have a set involving upwards of 20 firearms, would it be, in your experience, possible for a part-time armorer to manage that?
I wouldn't imagine so. One person can, each one of those weapons needs to be tracked pretty consistently for the set to remain safe. So I don't see how a single person can keep their eye on 20 firearms.
With regard to overall set safety,
And all of this is irrelevant to the legal question in this case, because Hannah had her eyes on the relevant gun. She had just loaded it. That she might not have had an eye on guns uninvolved in the shooting is irrelevant to the legal argument in this case.
safety, and your experience and background, who is in charge of that?
The first AD is considered in all of the published safety advisories, the chief safety officer on the set.
Are you a member of various guilds?
I'm a member of the Writers Guild, the Directors Guild, SAG-AFTRA, which is the Actors Guild, and I also happen to be a member of the Musicians Guild.
Okay, so when you talk about safety rules, are some of those from those guilds?
Yes, there's I can't remember the name of the organization, but they sort of collectively represent all of the various guilds and issue recommendations for safety that they recommend attaching to the call sheet each day.
Is it, in your experience, also something you've seen where there will be daily safety meetings on set, especially in a gun-heavy set?
Expert.
Yes, Your Honor. I believe he can give lay opinions on his experience, but also we would tender him as an expert.
I think we should approach.
Yeah, he's listed by the defense as an expert witness. Mr. Pesce is an expert witness on movie set safety, chain of command and protocols on movie set, roles of various persons on movie sets, and role of an armorer on movie sets. I was noting this. They were asking him substantive questions like, should an armorer be part-time? But they hadn't yet qualified him as an expert. They hadn't done all the, now they're doing all this, are you a member of guilds? But this dummy, Jason Bowles, is mixing up the questions. First you do background, expertise, guilds, publications. Is Your
So,
Honor,
Mr. Pesce, you were discussing some of those safety rules. Now, would it be, in your experience, advisable for production to convene daily safety meetings?
Yes, in fact, it's recommended by all of the published literature by the guilds. And it's been they recommend that a safety meeting takes place anytime there's to be any stunts, firearms, special effects. But it's been my experience, but in the last 7 or 8 years since the tragic incident with the camera assistant who was killed on the railroad bridge, that every first AD I've worked with, regardless of what's happening that day on the call sheet, has a quick safety meeting, just running over and reiterating basic safe practices.
And you as a director, is that something that you advise and you practice?
I don't give safety meetings. That's the job of the safety officer, the first AD, but I think it's a great idea.
In your experience and interacting with first assistant directors, if, for example, there's a situation where a set is rushing, there's safety issues occurring, does the first assistant director have any responsibility in that respect?
Most definitely.
And what would that be in your experience? What would you expect to see happen?
My experience has been that the first has an announcement to everybody, slow down, this is not safe, or we're not doing this, or just takes charge. And if there's a specific issue with a crew member, they'll pull them aside and discuss the issue and consult with stunts or props or firearms.
who would
and
consult with
deal with it.
Hannah?
Is that also true, for example, if you have a issue with an actor, for example, firing a blank after somebody yells cut, what would the first AD be expected to do in your experience?
Speak with them and indicate, look, when cut is called, usually the only person that can call cut is the director, but if it's a safety issue, anybody can call cut. And once cut is called, everything needs to stop, because if there is a safety issue, obviously, that somebody's noticed, nothing else should take place. So yes, the first AD should speak to that performer.
When it comes to safety, what is your view as to everybody's responsibility on set?
Well, again, it's not just my view, but again, in the published literature of the various guilds, they indicate safety is everyone's responsibility. If there's a safety issue, there are anonymous hotlines for anybody to call and raise these issues.
And are those anonymous hotlines, are those published generally in your experience working on set?
They're with that safety recommendations that are attached to the call sheet.
And those hotlines, what do they provide for people to be able to do if they notice a safety failure?
You can call someone from your guild. Each of the studios has their own separate hotline. And as far as I know, that will allow you to anonymously, so you don't look, if you report something, you could put your career in jeopardy. No,
What hotline call would have prevented Hannah Gutierrez from handing onto the set a gun with a live round in it? Why is any of this relevant?
nobody wants to do that, but the idea is that a representative can provide that information to somebody who will take action, such as the producer, the UPM, or the first AD.
The problem with all this is that Hannah Gutierrez herself, in 3.5 hours of interrogation, never said that things were unsafe. If anything, she said when she was pressured to put more attention on props than armor, she pushed back and stood her ground and had a strong personality.
In your experience, have you worked and seen the interaction between prop masters and armorers?
I have.
And can you tell the jury, in your experience generally, how they interact? Who's in charge of the firearms and who's in charge of the ammunition, and then what the prop master role is?
Well, the prop master, more often than not, hires the armorer because that's a subset of that department. But the armorer is in charge of all ammunition, all firearms, maintaining them, keeping them safe, and inventorying the ammunition.
With those duties and responsibilities, would you believe it to be important in your experience to accord the armorer adequate time to do those duties?
Yes.
And would it be important to accord adequate resources for that armorer to do those duties?
Yes.
With the gun, that matters. The gun that Hannah handed onto the set in the church that Alec Baldwin would use to shoot and kill Halyna Hutchins, Hannah never claimed, there's zero evidence in this case, that Hannah had inadequate time to prepare that gun. There's no claim to that. She had 3 extra hours in the morning because the camera crew had quit and they were getting things set up and they weren't filming yet to do her armor duties that day. That she might have had inadequate time or opportunity on some other occasion doesn't matter. What matters is in the preparation of this gun, the gun she handed into the set of the church with a live round in it.
If there is a scenario where the armorer is dealing with a gun-heavy set, not having those resources, who would you expect to assist that armorer in getting those?
Props.
If there is a situation where there is a scene, a video, something's happening, and both the armorer and first assistant director witness a safety violation involving a weapon, for example, what would be your assessment whether one or both of them should say something about that?
I would say both of them should say something about it and figure out why it happened and make sure it doesn't happen again.
Okay. Thank you, Your Honor. I have no further questions.
Cross-exam.
Mr. Pesce, I just have a couple follow-up questions for you. Thank you for your time today.
Certainly.
So anyone on the crew can stop filming due to safety concerns, is that right?
That's right.
And that includes Ms. Gutierrez.
That's correct.
And sir, did you read or watch the statements of Ms. Gutierrez in preparation for your testimony?
I did not.
That was my understanding. So are you aware that on October 21st, 2021, Ms. Gutierrez was not inside the church with the gun, not because she was working on props, but because she was just doing some other armorer duties?
Objection, Your Honor.
And I don't see a sound basis for objection here. I wonder what's, I wish they would leave this mic live for us. What is he saying here? This is a perfectly reasonable response to his implications on direct. That Props was keeping her away from her armorer duties. Oh, why can't we have speaking objections? All of this is like the private investigator's complaints about the investigation, like picking up the lieutenant picking up the revolver with no gloves on. It's all irrelevant. That witnesses should have been segregated. That somebody left the scene, but it's all irrelevant. We knew who that person was. He identified himself before he left.
Do I need to restate the question? Do you
Yes,
remember?
yes,
Okay.
please.
So my question for you is, we saw some interviews from Ms. Gutierrez, and she does explain that she was not in the church because she was preparing her fanny pack and her blank ammunition for the next scene. You agree that that's sounds like armor work to you, not props work?
Yes.
Okay. And are you also aware, sir, that on the morning of the 21st, when the crew was waiting for replacement camera personnel to arrive, Ms. Gutierrez had approximately 3 hours to work on her preparation for the scenes that day?
I was not aware of that.
Okay, thank you. I'll pass the witness.
Any redirect?
Just very briefly, Your Honor.
Okay.
Mr. Pesce, if there was a scene going on inside the church at that time involving Mr. Baldwin and the firearm, if Miss Gutierrez Reed was not in the church, would you have expected someone to have called her back in?
I would. If there's a firearm on set, there should be an armor on set.
Nothing further, Your Honor.
All right, thank you.
Again, completely irrelevant. If Hannah had been in the church, she would have been standing there watching Halyna Hutchins and Joel Souza get shot. She would have just been standing there. The bullet doesn't magically not fire. The live round that she put in the gun doesn't magically not fire because she's standing inside the church as opposed to 5 feet outside the church. Completely irrelevant.
You're excused. Thank you. Counsel approach.
Now, are there different hypothetical facts where it might have mattered? Whoops.
Instruction number 3.
Sorry, folks. I'm trying to save some time.
Next witness.
Yes. So say, for example, what happened here is that there was a malfunction with the revolver and the non-armorers, David Hall, Alec Baldwin, people were fiddling with the gun, trying to figure out what was wrong with it. And it should still not have had a live round in it, but the live round goes off. You might argue that had the armorer been fixing the malfunction, the shot would not have gone off. So then the armorer should have been in set. But on these facts, that's not what happened. The armorer in the church would have made zero difference. And now I expect what we're going to hear is that the defense rests and they're going to go into jury instructions. That's what I thought I just heard.
Yes.
Your Honor, at this time, the defense rests.
Okay, thank you. All right, so both sides have rested. It's now my duty to give you the instructions of law. I'm going to read them to you, and then you will get a copy of the instructions, okay? The instructions I'm giving you are very helpful for the counsel to use in their closing arguments, okay? Which will follow. All right, so instruction number 1, you have heard all the evidence. It is now my duty to tell you the law that you must follow in this case. Instruction number 2, the law governing this case is contained in instructions that I'm about to give you. It is your duty to follow the law as contained in these instructions. You must consider these instructions as a whole. You must not pick out one instruction or parts of an instruction and disregard others. A copy of these instructions will be given to you when you begin your deliberations. Instruction number 3. The law presumes the defendant to be innocent unless and until you are satisfied beyond a reasonable doubt of her guilt, his or her guilt. The burden is always on the state to prove guilt beyond a reasonable doubt. It is not required that the state prove guilt beyond all possible doubt. The test is one of reasonable doubt. A reasonable doubt is a doubt based upon reason and common sense, the kind of doubt that would make a reasonable person hesitate to act in the graver and more important affairs of life.
It's not a doubt based on speculation or imagination, folks. Well, for all we know, David Halls could have put the live round in the gun. Zero evidence.
Instruction number 4.
And reason requires evidence. That's the difference between reason and speculation. Speculation is a conclusion arrived at in the absence of evidence. Reason is the application of your powers of reason to evidence to come to a conclusion.
4. You are the sole judges of the facts in this case. It is your duty to determine the facts from the evidence produced here in court. Your verdict should not be based on speculation, guess, or conjecture. Neither sympathy nor prejudice should influence your verdict. You are to apply the law as stated in these instructions to the facts as you find them, and in this way decide the case. Instruction number 5. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agrees. Your verdict must be unanimous. It is your duty to consult with one another and try to reach an agreement. However, you are not required to give up your individual judgment. Each of you must decide the case for yourself, but you must do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own view and change your opinion if you are convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the purpose of reaching a verdict. You are the judges of the facts. Your sole interest is to ascertain the truth from the evidence in this case. Instruction number 6, each crime charged in the information should be considered separately. Instruction number 7, you must not concern yourself with the consequences of your verdict. Instruction number 8, you must not draw any inference of guilt from the fact that the defendant did not testify in this case, nor should this fact be discussed by you or enter into your deliberations in any way. Instruction number 9, you alone are the judges of the credibility of the witnesses and the weight to be given to the testimony of each of them. In determining the credit to be given any witness, you should take into account the witness's truthfulness or untruthfulness, ability and opportunity to observe, memory, manner while testifying, any interest, bias, or prejudice the witness may have, and the reasonableness of the witness's testimony considered in light of all of the evidence in the case. Instruction number 10. You should consider each opinion received in evidence in this case and give it such weight you think it deserves. If you should conclude that the reasons given in support of the opinion are not sound, or that for any other reason an opinion is not correct, you may disregard the opinion entirely. Instruction number 11. An expert witness is a witness who, by knowledge, skill, experience, training, or education, has become expert in any subject. An expert witness may be permitted to state an opinion as to that subject. You should consider each expert opinion and the reasons stated for the opinion, giving them such weight as you think they deserve. You may reject an opinion entirely if you conclude that it is unsound. Instruction number 12. For you to find the defendant guilty of involuntary manslaughter as charged in count 1, the state must prove to your satisfaction, beyond a reasonable doubt, each of the following elements of the crime. 1. Hannah Gutierrez endangered the safety of another by handling or using a firearm in a negligent manner. 2. Hannah Gutierrez should have known of the danger involved by Hannah Gutierrez's action. 3. Hannah Gutierrez acted with a willful disregard for the safety of others. 4. Hannah Gutierrez's act caused the death of Halyna Hutchins. 5. This happened in New Mexico on or about the 21st day of October 2021. Instruction 12A. For you to find the defendant guilty of involuntary manslaughter in count 1 alternative, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. 1. Hannah Gutierrez loaded live ammunition into a firearm intended to contain only inert ammunition, and or Hannah Gutierrez failed to perform an adequate safety check of the ammunition she loaded into the firearm. 2. Hannah Gutierrez should have known of the danger involved by Hannah Gutierrez's action. 3. Hannah Gutierrez acted with a willful disregard for the safety of others. 4. Hannah Gutierrez's act caused the death of Halyna Hutchins. 5. This happened in New Mexico on or about the 21st day of October, 2021. Instruction number 13. For you to find the defendant guilty of negligent use of a deadly weapon as a lesser included offense charged in count 1, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. 1. The defendant endangered the safety of another by handling or using a firearm in a negligent manner. 2. This happened in New Mexico on or about the 21st day of October, 2021. Instruction number 13A. For you to find the defendant acted negligently in this case, you must find that the defendant acted with willful disregard of the rights or safety of others and in a manner which endangered any person or property. Instruction 13B. In addition to the other elements of tampering with evidence, the state must prove to your satisfaction beyond a reasonable doubt that the defendant acted intentionally when she committed the crime. A person acts intentionally when she purposely does an act which the law declares to be a crime. Whether the defendant acted intentionally may be inferred from all of the surrounding circumstances, such as the manner in which she acts, the means used, or her conduct. Instruction number 14. You have been instructed on the crimes of involuntary manslaughter and the lesser included offense of negligent use of a firearm as charged in count 1. It is up to you, the jury, to choose the manner and order in which you deliberate on the crimes charged in that count. However, to return a verdict, you must follow the procedure described in the next instruction. Instruction number 15. To aid you in your deliberations and in returning your verdict, you will be provided both guilty and not guilty forms for each of the crimes charged in count 1. Unless you unanimously agree on a verdict, you should not sign a verdict form for that crime. Although you may deliberate on the crimes charged in count 1 in any manner and order which you choose, you must return your verdicts for each offense in count 1 in the order they are instructed. Under this procedure, if you unanimously find the defendant guilty of involuntary manslaughter, you should sign the guilty form for that offense and should not proceed to reach a verdict on the remaining offense in count 1. If after reasonable deliberation, you do not reach a unanimous verdict on involuntary manslaughter, you should not sign a verdict form for that offense and should not proceed to reach a verdict on the remaining offense. You should only return a verdict on negligent use of a firearm if you unanimously find the defendant not guilty of involuntary manslaughter. If you unanimously find the defendant not guilty of involuntary manslaughter, you must sign the not guilty verdict form for involuntary manslaughter before returning a verdict on any other crime charged in count 1. If you unanimously find the defendant guilty of negligent use of a firearm, you should sign the guilty verdict for that offense. If you do not reach a unanimous verdict on negligent use of a firearm, you should not sign a verdict form for that offense. Instruction number 16. In this case, as to the charge of involuntary manslaughter contained in count 1, there are 4 possible verdicts. 1, guilty of involuntary manslaughter. 2, not guilty of involuntary manslaughter. 3, guilty of negligent use of a firearm. 4, not guilty of negligent use of a firearm. You must consider each of these crimes. You should be sure that you fully understand the elements of each crime before you deliberate further. You have the discretion to choose the manner and order in which you deliberate on this count, but you must return a unanimous verdict of not guilty on involuntary manslaughter before entering a verdict on negligent use of a firearm. You will first decide whether the defendant is guilty of the crime of involuntary manslaughter. If you unanimously find the defendant guilty of involuntary manslaughter, then that is the only form of verdict which is to be signed as to this count. If you unanimously find the defendant not guilty of involuntary manslaughter, then you should sign only the not guilty form as to involuntary manslaughter. If, after reasonable deliberation, you do not reach a unanimous verdict on involuntary manslaughter, you should not sign a verdict form for that crime, and you should not proceed to reach a verdict on the remaining crime. If you unanimously find the defendant not guilty of involuntary manslaughter, you will then go on to a consideration of the crime of negligent use of a firearm. If you unanimously find the defendant guilty of negligent use of a firearm, then that is the only form of verdict which should be signed. But if you unanimously find the defendant not guilty of the crime of negligent use of a firearm, then you should sign only the not guilty form. If, after reasonable deliberation, you do not reach a unanimous verdict on negligent use of a firearm, you should not sign a verdict form for that crime. You may not find the defendant guilty of more than one of the foregoing crimes. If you have a reasonable doubt as to whether the defendant has committed any one of the crimes, you must determine that the defendant is not guilty of that crime. If you find the defendant not guilty of all of these crimes in count one, you must return a verdict of not guilty as to this count. Instruction number 17. For you to find the defendant guilty of tampering with evidence as charged in count 2, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. 1, the defendant Hannah Gutierrez had a baggie of cocaine by asking Rebecca Smith to take it outside of Hannah Gutierrez's hotel room, or hid a baggie of cocaine by asking Rebecca Smith to take it outside of Hannah Gutierrez's hotel room. 2, by doing so, the defendant intended to prevent the apprehension, prosecution, or conviction of Hannah Gutierrez for the crime of involuntary manslaughter. 3, this happened in New Mexico on or about the 21st day of October, 2021. Instruction number 18. A firearm means any weapon which will or is designed to or may readily be converted to expel a projectile by the actions of an explosion. The frame or receiver of a firearm, any firearm muffler or firearm silencer. Firearm includes any handgun, rifle, or shotgun. Instruction number 19. In addition to the other elements of the crime of involuntary manslaughter as set forth in instruction number 12A, the state must prove to your satisfaction beyond a reasonable doubt that 1, the death was a foreseeable result of Hannah Gutierrez placing a live round into a firearm intended to contain only inert ammunition, and or Hannah Gutierrez's failure to perform an adequate safety check of the ammunition she loaded into the firearm. 2, the act of the defendant was a significant cause of the death of Halyna Hutchins. The defendant's act was a significant cause of death if it was an act which, in a natural and continuous chain of events, uninterrupted by an outside events, resulted in the death and without which the death would have not occurred. There may be more than one significant cause of death. If the acts of 2 or more persons significantly contribute to the cause of death, each act is a significant cause of death. Instruction number 20. The state must prove beyond a reasonable doubt that the defendant's act was a significant cause of the death of Halyna Hutchins. An issue in this case is whether the negligence of a person other than the defendant may have contributed to the cause of death. Such contributing negligence does not relieve the defendant of responsibility for an act that significantly contributed to the cause of death, so long as the death was a foreseeable result of the defendant's actions. However, if you find the negligence of a person other than the defendant was the only significant cause of death, or constitutes an intervening cause that breaks the foreseeable chain of events, then the defendant is not guilty of the offense of involuntary manslaughter. Instruction number 21. Now the lawyers will argue the case. What is said in the closing arguments is not evidence. It is an opportunity for the lawyers to discuss the evidence and the law as I have instructed you. The state has the right to argue first, the defense may then argue, and the state may then reply. Counsel?
Thank you, Your Honor.
All right. Harry Morrissey. This is it, Carrie. This is the big play. Got to bring it all now. They should have an IQ number like floated above her head, and then like a double-digit IQ number above Jason Bull's head, like a thought balloon.
Good morning, ladies and gentlemen. May it please the court, counsel. I want to begin by thanking you all for your time. I know that this has been a long trial, and I also understand that as jurors, you find yourselves maybe a little frustrated. There's a lot of sitting around and waiting, and we appreciate your time. We appreciate the sacrifice that you make when you leave your jobs and your families and your other responsibilities, and you come to court to participate in a very, very important part of our justice system. So on behalf of the state of New Mexico, we thank you very much for your time. And as you can see on your screens, we end exactly where we began, in the pursuit of justice for Halyna Hutchins. I want to start by just generally outlining Hannah Gutierrez failed to maintain firearms safety, making a fatal accident willful and foreseeable. And please keep in mind that omissions can also be willful. So if we fail to do something that we should do, and that failure results in someone's death, then that too can be willful. So I would ask that you keep that in mind as we move through some of the evidence and testimony that you have heard. I know that you have heard a lot, and I do not intend to keep you too long, but I do have to be thorough. I do want to hit some high points. So I do appreciate your patience. Here's what we saw. These videos, if you recall, that were taken by Production Outfitters, they were taken on October 13th of 2021. What these demonstrate to you is that Ms. Gutierrez was unwilling to maintain proper firearm safety repeatedly. And it's really important because this is not a case where Hannah Gutierrez made one mistake, and that one mistake was accidentally putting a live round into that gun. That's not what this case is about. This case is about constant, never-ending safety failures that resulted in the death of a human being and nearly killed another. So let's talk about all of the safety failures that we saw, and the reason that these safety failures prior to October 21st are so critically important to the analysis is because they go to foreseeability. And foreseeability is a very important element in this case. So as we can see here, we have our stuntman with his double barrel shotgun. From watching those.
So when Morrissey here is hammering on this foreseeability option element, she's explicitly gutting the intervening cause defense, that the defense will try to argue that, but for Alec Baldwin pointing the gun at Halyna, this would not have happened. That was the unforeseeable intervening cause, should relieve Hannah of liability. here, the reason Morrissey's talking about all these other safety violations is that in the context of all of those, it was not unforeseeable that people would point a gun at each other. We saw other people pointing guns at each other all the time, is what I expect she's going for.
Those videos, what you understood is that Ms. Gutierrez did appear to, in fact, be present, because at times we saw her and at times we heard her. So she wasn't off doing prop duties. She was right there and she never intervened. Gun pointed at a child. Gun pointed at Joel Souza directly at his back. Gun pointed up in the air in the direction of the stunt coordinator. Gun pointed again, apparently in the direction of Mr. Souza, the person on the far right. Gun pointed directly at Mr. Souza again, the firearm in the left hand of the stuntman who is facing you. Firearm pointed directly at a minor child. Firearm pointed directly at the camera. Ms. Gutierrez, holding that same firearm with the muzzle pointed at her own face. This was unexpected. Ms. Gutierrez stood by and did nothing in between scenes when that stuntman, who had certainly been sent the message that he could do whatever he wanted with those guns, no one was going to intervene. The person tasked with intervening was not going to do it. That was clear. He hands the firearm to the child and allows the child to manipulate the gun before then, after a short period of time, perhaps thinking better of it and taking the gun back. This firearm, I actually don't think in this photo that the firearm is pointed at the child. I think the firearm is, based on the angle of the camera, probably more pointed at this person right here. But she's there. We hear her, we see her. She does nothing. Absolutely nothing. This is some of the first evidence that we see where if something doesn't stop, if something doesn't change, she is moving in the direction of potentially a fatal incident, and that is exactly what happened. And I want you to recall Ms. Gutierrez's interview on November 9th, when Ms. Gutierrez spoke of the accidental discharge with the other stuntman, having a complete lack of understanding of her role in safety on this movie set. She's talking about Sarah Zachary, and she was like, well, yours just went off in there after you loaded it. And I said, yeah, well, I can't be responsible for every dickhead fucking stunt guy that gets a hold of the gun and doesn't understand the concept that it's hot. Her entire job is to be responsible for exactly that. And when she took this job, she agreed to that responsibility. There is no exception in the law for you're young. The exception in the law does not exist. The law treats everyone the same, and it must. What was the point to the testimony about the lever action rifle? Well, here's the point to the testimony about the lever action rifle. more negligence, more carelessness, more lack of attention to safety. She loaded a lever action rifle with dummy rounds that, by the way, according to the director, was completely unnecessary. Because yes, while it's true, this gun operates in a way where if a certain type of camera angle is hitting it, dummy rounds would be appropriate if the scene calls for loading or cycling. There wasn't a scene that called for that. So she just loaded a lever action rifle with dummy rounds and surprisingly put the wrong caliber round in the gun. That is absolutely an example of someone who is not paying attention, not taking their job seriously. I want to talk to you a little bit about some of the rounds that you've seen because it's critical to tracking the existence of the live rounds on this movie set. And we have spent a lot of time and effort tracking those rounds around that movie set. And we're going to show you that evidence right now. So the important thing to know is that the Seth Kenney dummies, which you are looking at right here, are patinaed. They are distinct. They have an antique coloring. They also have silver primers. These rounds did not come on that movie set until October 12th of 2021 because Mr. Kenney didn't have them. And if you recall his testimony, he was in Texas. So he had to get back, clean them up, and provide them to Sarah Zachary. And that took place on October 12th. This is just simply the primer side of those rounds. You can see that they're dark in color on the primer side, and they do appear to have silver primers. This is a photograph of the 3840 dummies. If you recall Mr. Kenney's testimony, the 3840 dummies came from Billy Ray. And the important thing about this photograph is that none of those dummy rounds had silver primers. And silver primer is a very important piece of this puzzle. This is those same rounds on their side. You can see that they are shiny brass. We also know that they have brass primers. We just saw that. Based on Mr. Kenney's testimony, you know that they were 3840, but there was also some 4440 caliber rounds in that box. Does that matter if they're not working? Well, let's stop.
It is now.
Okay.
Thank you.
Let's take a moment to talk about all this testimony that you've heard about whether or not the live rounds found at PDQ, which are photographed there on the left, match the live rounds found on the set of Rust. You don't have to be a gun expert to look at those and see they simply do not match. Even though you could look at those rounds and fundamentally understand that they are not the same, the police department, the sheriff's department sent them to the FBI for testing so that we could actually have some experts confirm what we can see with our very own eyes. And what you have in evidence, if you want to see them in real time, you have State's Exhibit 79, you have State's Exhibit 91. State's Exhibit 79 is a disassembled live round from PDQ Props. State's Exhibit 79 is a disassembled live round from the set of Rust. You can look at them. You can see the projectiles are different. You can see that Perhaps the primers are even different. If you recall, Ms. Popple indicated there were only 10 silver primered live rounds found at PDQ. The rest of them were brass. The other thing that you can just see with your eyes is the gunpowder in these is substantially different. It has a different chemical composition. So any argument that could ever be made in this case that Seth Kinney was the source of these live rounds is absolutely dishonest.
Bam! Bringing the heat.
Now, I'm going to ask you to take a walk in the weeds with me here, okay? This is a photograph of October 10th of 2021. You can see the color of the rounds at the top. Those are brass primered rounds. The rounds in the bottom appear to be lighter, and I would suggest to you, based on the totality of the evidence that we're going to go through, that you are looking at live rounds. And keep in mind, anything that you see on the set of this movie that is a revolver ammunition, prior to October 12th, if it has a silver primer, it's a live round. Because the silver primered dummies didn't come on set for 2 days after this photograph was taken. Here's our comparison photo that Mr. Primo put together for us. And
Primo,
if
the
you need it
$10,000 man.
when you're reviewing the evidence and doing your deliberations or engaging in your deliberations, I have included it for you. But we're going to do a comparison here in a moment. Now, the importance of this photograph, still October 10th of 2021. There appears to be revolver ammunition in the background there at the top. 2 of those have silver primers. The problem with that is the silver primer dummies weren't there yet. But the live rounds were. And there's your close-up. It's absolutely undeniable. Is it blurry? Yes. Can you clearly see the difference? Absolutely. All of these photos that you're looking at were October 10th. Now, let's move to October 13th of 2021. I invite you to look at that photograph carefully and ask yourselves, which of these is not like the others? It's the third one from the left. Look at the shape of that projectile and look at the color of the brass. So on October 13th, Mr. Kinney's dummies have arrived on set. They are the only dummy rounds with silver primers, but they are patinaed in color. So when you look at this round, it appears to be a spot-on match for the live rounds, but unfortunately we can't see the primer in this photo, so we can't tell if this is a brass primered dummy. That's the reason that we watched thousands of videos and looked at thousands of pictures, because then we moved to the production outfitter videos from October 13th, the same day. And we're looking at that same gun holster that was provided to Mr. Baldwin. And there you see it. The third one down has a silver primer. And now you know it is a live round. You know that because it's not a Seth Kinney dummy. If it were, it wouldn't have that shiny brass color. So there's your live round. We've seen it on October 10th. We've seen it on October 13th. And there's absolutely no way that the lighting is playing tricks on our eyes when we're looking at these enhanced photos, because you see it frame after frame after frame. And now let's move to October 15th. Karen Kuhn arrives on set. I think she was probably there long before the 15th. She is taking photos. She took approximately, as she testified, 9,000 photos. So on the 15th, there it is. There's your silver primer. It's just been moved to a different location in the holster because they're pulling dummy rounds from here, there, and everywhere and putting them in belts and putting them in guns and doing whatever they want to do. But there it is. It's right there on October 15th. And if you think I'm stretching it, let's have a look at what we've got here. This is the gun belt that was assigned to actor Jensen Ackles. Because his gun belt was not a shoulder holster, we weren't able to find any photos or videos of it in the thousands and thousands and thousands that we reviewed, because they're always covered by his coat. There is the evidence photo of the Baldwin holster on October 21st when it is taken into evidence. You have a Seth Kinney dummy at the top. You have what the FBI determined to be a live round in the second spot. And then you've got 3 brass primered dummies. October 17th, October 21st. So the video that Mamie Mitchell laid the foundation for, she said that according to her notes, the filming was done on the 17th. Mr. Primo said that he believed, according to the camera, it was the 18th. Take whatever date you want. That's a match. Seth Kinney dummy at the top, live round next. You've got 3 brass primer dummies on the 21st, 4 brass primer dummies on the 17th or 18th. But it is shockingly the same. And there is no question that this one right here is a live round. It was sent to the FBI and they confirmed it. This is Ms. Gutierrez talking about her bringing these dummy rounds on set. I had a multitude of the ones with holes and the ones that you shake. So yeah, and I checked those all and I put them into 2 things. And then we start talking about boxes. Obviously, when she says things, she's talking about boxes. They usually had JS on them. This is one my dad sent me, and mine are usually beat up pretty bad, like they're very dirty and gross. She's talking about the box and the styrofoam insert. The box and the styrofoam insert, she's saying, are dirty. Hers, the ones that she brings on set, are dirty. They're not new and clean like some of the other ones. Detective Hancock asks her, this is the one that was or handed that you guys had said that you had pulled from. This is that moment in that interview where Ms. Gutierrez has already shown Hancock the photo from her dad, and an hour or 2 later, Detective Hancock decides that now is the time to show her the photo of the box of dummies she was pulling from that day, and it won't surprise you to learn they're a spot-on match. You have the styrofoam insert from that box of dummies here in evidence, and the reason that we gave it to you so that you can actually look at it in real time and not look at a photograph is because it's kind of dirty and gross. It kind of fits exactly the way that she described it. But there are some characteristics of this styrofoam insert that are going to become more important. Any suggestion by the defense that somehow the box of dummy rounds that Ms. Gutierrez said she was pulling from was swapped out with something different is absolute nonsense. First of all, you know that because you can see the live rounds. If you don't think you can see them on the 10th, and you don't think you can see them on the 13th, and you don't think you can see them on the 15th, you know you're looking at one on the 17th and 18th. You know you are. So where does the sabotage theory go then? The 17th and 18th, the camera crew hadn't quit yet. Mr. Norvell wasn't on set poking around on the prop cart. Mr. Halls hadn't had an opportunity to spend any time with the gun. They moved directly from that cart right into Lieutenant Benavidez's patrol unit. They go from that patrol unit right into evidence at the Santa Fe County Sheriff's Department. And on November 9th of 2021, Hannah Gutierrez shows Detective Hancock, now Corporal Hancock, the box of dummies that she and her dad have. And if you listen to Mr. Kenny's testimony, what you understand is that the ammunition from the previous set, that being the old way, Hannah brought leftover dummies from that movie onto the set of Rust. And those 45 long Colt dummy rounds were provided by Thel Reed. What you are looking at in this photo is this styrofoam insert. This is the styrofoam insert that had the live round in it. This is the styrofoam insert that came out of the box labeled 45 long Colt dummies with the JS in the middle. Now, let's put it together. Our original evidence photo up here from October 10th, you can see this distinct sort of cut in the styrofoam on that insert that is sitting on her leg on the 10th. You can see that the hole in the styrofoam in the second to the right at the top is dirty. You can see a little bit of grime. You can see it right there. And you're going to take it into evidence and you can look at it closer. You're going to see that there's some damage to the styrofoam separators between these two holes. And what do you know? It's right there. There's a little bit of damage to the styrofoam separators down here. You can see it in the photo on the right. You can look for yourself. It is right here. And what do you know? That silver primered round from October 10th is sitting in the exact same position that it was found on October 21st when the Sheriff's Department collected this box, took it into evidence, and photographed it. Ladies and gentlemen, we call that circumstantial evidence, but that's a mountain of circumstantial evidence. Prop assistant duties versus armor duties on October 21st of 2021. Let's focus on that day. And listen, I'm not here to tell you that Rust Productions did the right thing when they hired on a part-time armorer and asked her to also spend her time doing props. I think everybody who has testified has said that was a really bad idea. And that's probably part of the reason that they're being sued by a whole bunch of different people. But on October 21st, this was simply not the case. It was not the case on that day. She had 3 hours in the morning waiting for the camera crew to arrive. She had every opportunity to go through that box of dummies, that only had like 30 rounds in it. How long does it take to pull the round out of the box, shake it, and if it doesn't shake, look to see if it has a hole in it, put it back in the box, and do that to each and every one of them? How long does that exercise take? 10 minutes max? That's not hard. The other thing that is very important is Ms. Gutierrez didn't get pulled out of the church because she had to go focus on prop duties. She left the gun in the church contrary to all the industry standards for armors on movie sets, for firearms safety on movie sets. And she went back out to her cart so that she could start doing other armor duties. She's getting her fanny pack filled up. Well, we've seen that. She's filling it with blanks. And we know they're about to do a turnaround. They're going to do this quick insert with Baldwin, and then they're going to do the shoot scene, the gunfire scene where they're using blanks, and the law enforcement have come into the church and there's a shootout. So she goes to get ready for it. She just leaves the gun in there. As you heard from many witnesses, she would leave guns unattended all the time. There was nothing unusual about October 21st that caused her to be unable to stay in the church to properly perform her duties. She leaves the gun. She goes back out because for some reason, with the 3 hours of free time that she had in the morning, she didn't get her fanny pack filled up. She didn't get herself ready for that turnaround. So she leaves the gun. Everybody's heard armorers don't leave the gun. Now, let's move over to our tampering with evidence charge. How is getting rid of a bag of cocaine tampering with evidence related to involuntary manslaughter? Well, on October 21st, 2021, the shooting occurs, the incident occurs. Ms. Gutierrez understands that someone has been seriously injured. She does not yet know that that person is not going to live or has already died. She gets interviewed at the Santa Fe County Sheriff's Office. I will say, surprisingly, 2 occasions after this incident where a helicopter had to come in, ambulances had to come in, Ms. Gutierrez, on 2 occasions after that incident, spoke about her concerns about her career. Wow. That gives you an idea that you are dealing with someone who is not particularly concerned about the health and safety of others. And her job was to be concerned about the health and safety of others. But on that day, she's just thinking about herself. She's put a lady in the hospital, a man in the hospital. She asks to be escorted to the bathroom. Corporal Hancock agrees to do that. And we have her on video on the way there expressing dismay about how this will affect her career. Ouch. After the interview, Hannah goes back to her hotel. Rebecca Smith goes to Hannah's room. She's been summoned by some other folks to try to sort of sit and visit and give Hannah some support. So Rebecca Smith goes to her room, and Rebecca Smith is the person that tells Hannah that Halyna Hutchins has now died. And you have to understand, in the mind of Hannah Gutierrez, this investigation went from this big to this big. Because the difference between shooting someone and them living and shooting someone and them dying is a really, really big difference. So she is told by Rebecca Smith, investigation just got giant and very, very serious. So after receiving that information, she offloads this bag of cocaine to Rebecca Smith. Rebecca Smith is a lady that's lived a life. She's used cocaine before, many years previous, but she's used cocaine. She knows what it looks like. She knows how it's packaged. And because she's a former addict, she tosses it in a trash can. When Mr. Bowles gets up here and says, I can't prove to you that it's cocaine, remember that when people destroy evidence to avoid prosecution, you don't have the evidence that they destroyed. They got rid of it. So I don't have to prove to you by some scientific drug test. I don't have to send that to the lab and get it tested. It's gone. That's the point to the charge.
Mention the text messages.
Now,
Oh.
let me digress a little bit and run through a couple of things with you. What's all this testimony about this inertia puller? And how's that play into everything? Well, as you heard from Mr. Haig, an inertia puller is a device designed for one task. It disassembles live rounds. That's what it does. Somehow I think the defense got confused about what our potential theory was, that we had a theory that Ms. Gutierrez was turning dummy rounds into live rounds. That was never our theory, because that would require quite a bit of equipment. There's no question. But to do the reverse is a whole lot easier. So if you're out of dummy rounds or you're running low on dummy rounds and you've got some live rounds around, you could probably turn a you could turn a live round into a dummy round in 5 minutes. Why does an armorer on a movie set bill for an inertia puller? Well, obviously she had one. Now, let's talk about the OSHA investigation. OSHA doesn't find any wrongdoing with individual employees, only employers. That's their job. They're just an agency that maintains workplace safety. Mr. Genoway confirmed when he was on the witness stand, it's true, his memory was a little bad and Mr. Lewis had to refresh it for him, but he confirmed that Hannah's conduct on the set contributed to their findings that this was not a safe workplace. Please keep in mind that the OSHA investigation is not a criminal investigation. Critically and surprisingly, OSHA never interviewed Gabrielle Pickle. This is critically important because if they had interviewed her, they would have known the following things. Hannah was granted 10 armorer days out of the 12 filming days, not 8. That was right there in the cell phone records. The training days, when Ms. Gutierrez is sending those messages saying, I want more training time, training days. She's not saying these actors, these adults need more training time. She specifically requested additional training time to train the child. And it was refused because, first of all, it's a major liability issue. And second of all, the child was never going to fire a gun. So when she asked for the additional training days, they were denied. That's not the reason Halyna Hutchins is dead. Keep in mind, Gabrielle Pickle had a meeting with Hannah and offered her additional assistance so that she would be able to perform her duties effectively. She offered assistance from some of the other folks there on set to try to give her some relief. And keep in mind that on a movie set, the armorer has autonomy with regard to gun safety. The OSHA finding that Rust Productions failed to properly supervise her is surprisingly incorrect, because the armorer has no supervisor when it comes to weapons and gun safety on the movie set. Mr. Halls is just there to be a second pair of eyes. That's it. Now, I think there can be no question that Rust Productions was more than negligent when they hired Ms. Gutierrez, because she was not anywhere close to being qualified for this job. In fact, if you recall, Gabrielle Pickle, to her credit, tried to get Ms. Gutierrez to implement a check-in and check-out system because 2 people had complained that there was a shotgun left unattended. People on the set were complaining about her. They went to production and said, hey, she's not supposed to do that. You can't just leave real guns laying around. So Gabrielle Pickle goes to Hannah Gutierrez, asks for a check-in, check-out system. Hannah Gutierrez says no. Hannah Gutierrez says it's too difficult, it's too much trouble. Gabrielle Pickle didn't prevent her from being safe. In that instance, she did the opposite. She tried to improve firearm safety on the set, but keep in mind, the armorer has autonomy. So Gabrielle Pickle is not Hannah Gutierrez's boss when it comes to firearm safety. Ms. Gutierrez gets to do what she wants. Now, I can only imagine that after this chain of cases, all of that will change. So the defense has taken a shotgun approach to this case. Seth Kinney is to blame. Well, no evidence of that. Sarah Zachary is to blame. No evidence of that. Dave Halls is to blame. He shouldn't have taken the gun from her, and he didn't do a good safety check. Well, she is the autonomous decision maker with regard to gun safety. It's not that Dave Halls shouldn't have taken the gun from her. It's that she shouldn't have given him the gun and then turned around and walked away. The defense. Alec Baldwin is to blame for acting like a prima donna on the movie set and bossing people around. This is Hollywood, for heaven's sakes. I would imagine that's relatively common. Don't get me wrong. I'm not saying that his conduct was right. I am the person who indicted him. Alec Baldwin's conduct and his lack of gun safety inside that church on that day is something that he's going to have to answer for. Not with you and not today. That'll be with another jury on another day. Brian Norvell, the gentleman who goes and gets the prop cart and wheels it over and then puts his hand over the crime scene tape and picks up that dummy round and shakes it. You heard Mr. Bowles ask some questions that are intended to make people think that Mr. Norvell either took something off the prop cart or planted something on the prop cart. Well, keep in mind, he doesn't have to plant live rounds because we've seen from the photographic evidence, those are there. They're floating around already. So live rounds were on set. They were not planted by Brian Norvell. But this man is not a mystery to the state or the defense. I made him come in and sit down for a 1.5-hour interview so that the defense could ask him any questions they wanted, and they asked him none. Not a single question. So what that means is that this is just all smoke and mirrors and deflection. They don't want the truth. We know the truth. You have seen it throughout this trial. And I will remind you that during one of the heated objection exchanges between myself and Mr. Bowles, you heard Mr. Bowles cry out that he was looking for the truth. Listen, I can bring a horse to water, but I cannot make him drink. If you want the truth, I'll bring the guy in. I'll make him available for you to talk to. Ask him some questions. Not a single one. It must have been that disgruntled camera crew. You mean the people who believed that safety on set was being compromised to such a degree that they left? That decision may very well have saved their lives. So, the $60,000 question in this case, who brought the live rounds on set? You know the answer to that. I know the answer to that. I'm not telling you that Hannah Gutierrez intended to bring live rounds on set. I'm telling you that she was negligent, she was careless, she was thoughtless. She brought them on set, and you know from the testimony you heard, Sarah Zachary never saw her shake a dummy round. Dave Halls never saw her shake a dummy round. She didn't shake those dummy rounds. For all we know, those dummy rounds were floating around the set of The Old Way, and Nicolas Cage is lucky to have walked away with his life. So why does it matter that she brought live rounds on set? It goes to foreseeability. She had six live rounds on that movie set. The earliest date that I can track them for you is October 10th. We know that they were there from the 10th to the 21st. 6, and she failed to ferret them out for 12 days. What that means is that she wasn't shaking any dummy rounds. She wasn't testing anything. None of that stuff that her lawyers want you to think was so difficult. None of it was happening. It didn't happen the entire time. She didn't find any of them.
Ouch.
And folks, if she's not checking the dummy ammunition during the pendency of the filming to make sure that those rounds that are designed to look like live rounds are in fact dummy rounds, this was a game of Russian roulette every time an actor had a gun with dummies. Sadly for Ms. Hutchins, her camera crew walked off set that morning, and that required her to go into the church and operate the camera herself. And that's what she was doing when the live round that Ms. Gutierrez put in Mr. Baldwin's gun was expelled from that firearm and went all the way through her body. No one told Ms. Gutierrez to leave the church. No one called her out of the church. There wasn't a COVID protocol in place that prevented her from being in the church at that moment. You know from the production outfitter videos, she didn't care about her job. She let it all go. Mr. Bowles is going to argue to you that if Mr. Halls had just called Ms. Gutierrez back into the church, she would have done an additional safety check and that live round would have been found. Well, for heaven's sakes, we all know that if she had been called back into the church for an additional safety check, nothing would have changed. Her safety checks didn't consist of pulling the dummy rounds out of the cylinder, shaking them in front of the actor and the assistant director, showing them that they're dummy rounds, and putting them back in. No one ever saw her do that one single time, even though that's industry standard. And the reason it's industry standard is because you can't tell a dummy round by simply spinning a cylinder and looking at the primers unless they are dummy rounds without primers. And that's kind of an interesting fact. We know that 6 dummy rounds without primers were not loaded into that weapon because one of them turned out to be live and very clearly had a primer. Interestingly, though, she had 5 dummy rounds without primers in her pocket. In her pocket. All she had to do was put those in the gun, make sure that the 6th one either rattles or has a hole in it, and she's good to go. Because now, when you look, when the cylinder gets spun, you can see 5 of them without taking them out, that they don't have primers. They were in her pocket, and she didn't use them. I am going to have another opportunity to speak with you, and when I speak with you last, it won't be as long, I promise. And we will talk about some of our jury instructions then. But I do want to address some of the testimony from Dr. Gerald from OMI, because Mr. Bowles is likely to make an argument that there was some sort of medical negligence that contributed to Ms. Hutchins' death. And I want to talk to you a little bit about Dr. Gerald's testimony. Here are the lethal injuries. The lethal injuries: blood loss from the wound. That was the primary lethal injury. Her blood was leaking into her abdominal cavity, and a lot of it. And you saw those photographs. You saw the photographs of her clothing. There was a lot of blood. So the first lethal injury that comes from the gunshot is blood loss associated with it. And the second one, if you recall from Dr. Gerald, the wound to the lung was also a lethal wound. Keep in mind, that bullet went into her body, it went through her rib, it severed her spinal cord, it punctured her lung, it came out the back of her shoulder, and a few hours later, Ms. Gutierrez is telling Corporal Hancock that she's worried about her career. If you think that person would have done a satisfactory safety check if she had been called back to the church, I am here to tell you that I strongly disagree. The astonishing lack of diligence with regard to gun safety is, without question, a significant cause of the death of Halyna Hutchins. Did Mr. Baldwin also contribute when he pointed the gun at people and pulled the hammer back, and regardless of what he said to George Stephanopoulos, pulled the trigger? Yes, he is. And again, we'll deal with that another time. You don't escape accountability when you load a live round into a prop gun, tell the crew that it has dummy rounds in it, hand it off to an actor, and leave the room because he manipulated it. That's the whole point. That was the whole point to him having it. Of course he was going to manipulate it. It's foreseeable. Everything is so completely foreseeable. Imagine I hand you a gun and I tell you that it's basically empty and I walk away when in fact, I put live ammunition in it. You think an accident might happen? You think that accident is foreseeable? And listen, let's remember some of the testimony from Mr. Carpenter. Control is how we enforce gun safety. We do it with control. When she loses control, which she did repeatedly, anything goes. Anything goes there. I am going to complete the majority of the portion of my closing arguments with regard to the facts. The next portion will be with regard to the law. When I come back after Mr. Bowles has had an opportunity to address you, we will be asking for justice today for Halyna Hutchins. Thank you.
May we approach?
Well, if it's about a bathroom break, we're going to take a bathroom break.
Okay.
Okay. So please don't talk among yourselves or anyone else about the evidence received here in court. Thank you. We'll be back at 10:00. Okay?
10-minute break. 10-minute bathroom break. Let me put that up. Let's see. Court break until 1:50 p.m. Eastern Time. All right, and I need a bathroom break too. So where were we? We were doing I was playing something. What was I playing? Let's see if I can find it. Oh, I was playing the kooky firearms expert. Let me pull him back up during this bathroom break. And I'm going to go hit to John, and I'll be right back, everybody.
Okay, sir. Now, the first thing I want to ask you, comparing the Denix, the replica, to the real, the Pieta, do they share some of the same characteristics?
Yes, they do.
And can you tell the jury, is the Denix made to look like the Pieta?
Absolutely.
And side by side, if you can, and Your Honor, may he step down to show the jury?
Yes.
Okay. Sir, if you can show them the Pieta and the Denix side by side, just so they can see.
This is a Denix. It is a replica, totally unfiring with a block barrel. It functions completely like a regular revolver. The cylinder turns, it will cock, it will snap and fire. It's unable to fire any ammunition. It's used as a replica. It's made of metal, and it functions just like a single action Army Colt, but it can't fire. I'll bring the next one, and then we'll compare them. Next gun in the same position. This is a P8 revolver. This is the sister gun to the Baldwin gun. It's a .45 caliber single action 1873 revolver, like was issued to Custer's troops. It is a true .45 long Colt. We call it just Colt. And it was designed for the U.S. Army to be able to kill a man and a horse. And it was the most popular firearm in Western movies.
Thank you, Mr. Kuski. If you could.
Now may I show the two together?
Yes, if you will just show what, but not with testimony, but just showing them.
I'll reverse them.
Mr. Kuski, in your review as an expert in this case, are you aware whether there was a Denix revolver like that on set on Rust?
Yes, there is. It was covered in the invoices as rented by Rust Management.
Now, not demonstrating at this point, but can you tell the jury based on what you just?
All right, so let's do a quick poll after that closing. Now, we haven't heard defense closing yet, so we, keep that in mind. Okay. And for the members, the law of self-defense members, either participate on YouTube in the poll or just put your thoughts in the comments. And the choices are guilty, not guilty, hung jury. Guilty, not guilty, hung jury. Okay. Let's look at the law of self-defense comments. Remember, you can become a law of self-defense member, get your comments and questions answered for free for just 99 cents, folks, at lawofselfdefense.com/trial. So, law of self-defense member Brad predicts that the jury will be out just long enough to fill out the paperwork. Kevin asks, if she's found guilty, does that exonerate Baldwin? Because that's what he's going to say. No, it doesn't work. It doesn't have anything to do with Baldwin. It's not one pie of responsibility that's shared for everybody. Each person has their own pie of responsibility. Many people can be guilty. And I predict many people will. I predict David Halls is already guilty. He's pled. Hannah Gutierrez should be found guilty on the legal merits. And Alec Baldwin should be found guilty on the legal merits. And then Rust Productions and a whole lot of other people should be civilly liable. Law self-defense member Will says, I think her daddy made it look so easy being an armorer that she was overconfident about what she knew and didn't think about not knowing. Yeah, and this happens a lot where you have layered. You have layered safety. It's easy for people to become complacent. So you have, let's use the 4 safety rules. You have 4 safety rules. If you only violate one, you don't get a bad outcome. So you can be violating that one safety rule 1,000 times. You don't have a bad outcome. And it feels like things are being done correctly. But the moment you have a second failure of a second rule, then you have the bad outcome. But until that happens, you're actually doing it wrong, but not having bad outcomes. So it feels like you're doing it right. That's what happened apparently with Hannah Gutierrez. That Hannah Gutierrez had live rounds on the set, and she was getting away with it. They just weren't being loaded into guns that were being fired until she got unlucky. The risk was always there, but the risk wasn't realized until October 21st. Yeah, and we can't presume just because her dad's a purported expert that she has any expertise, right? I'm an expert in use of force law. My kids are not experts in use of force law. I thought Morrissey did a really good job distilling down, 10 days of witness testimony into a relatively short period of time. By the way, how much of the testimony against Hannah Gutierrez, just recited by Special Prosecutor Kerry Morrissey, how much of that testimony against Hannah Gutierrez came from Hannah Gutierrez in her 3 hours plus of police interrogation, the large majority of which was sitting beside her attorney, Jason Bowles. Does she know what the cocaine smells like? That's funny, Eric. That's funny. Yeah, I mean, I think a better lawyer would have helped her because she would have had better facts, because she would have not have done at least that second interrogation the same way. And that's the one where she showed the box from her father. Lots of stuff. Lots of the evidence in this closing, recounted in this closing, came from that second interrogation. And he didn't ask any questions of that witness that in court he would try to suggest had tampered with the scene, had planted evidence. Member Elman says, I hope actors get very aggressive with onset safety now. Imagine what these actors and the crew feel like now, right? Jensen Ackles. We saw some of his interview over the last few days. You think he's not thinking that could have been me? Either fired the shot or got hit by the round? Everybody on that set is thinking that. It could have been me who got killed or maimed in the shoulder. They were all at risk. Law self-defense member Joe is saying when Bowles was taking notes during Morrissey's closing that he was writing down crap. Can't say that now. She's cut him off at the pass. Joe asks, is the prosecutor going to be the same in the Baldwin case? Yes, the same special prosecutor, Kerry Morrissey. Different defense counsel. not surprisingly. Yeah, she didn't bring in the safety check, the barrel obstruction check where Hannah would just point the revolver barrel at her face. You can only cover so much. Guilty, guilty, guilty. Law self-defense members are saying guilty. Guilty, but she never had a chance. She was completely unqualified. Well, she had a chance. She had a chance not to take the job. Yeah, when I say she's guilty, of course, I mean on the legal merits, she's guilty. I have no idea what the jury's going to say. And once again, the court's late coming back from break. Every time. Morrissey is a very good lawyer. Very good lawyer. It's not common. I mean, I know several. I mean, most lawyers aren't very good. So, but she's very good, Carrie Morrissey. I'm a big fan of her as a lawyer. Yeah, I don't know why she didn't bring up the text messages about the cocaine. That was a mistake because that, to my mind, that is the circumstantial evidence that it was cocaine. There's no reasonable explanation for those text messages other than the baggie contained cocaine. I think that was a misstep. Maybe she'll hit it on rebuttal. Dave says, is it typical that a defense lawyer responds to police questions on behalf of their client in an interview? Sure, all the time. All the time. Usually they're very careful how they coach it. I mean, they might just tell their client not to answer that question. Or they might interrupt and say, well, I can tell you that we're prepared to offer that X happened this way. Member Lee says, when I was in legal assistance school, before I decided to go to law school, our instructor in criminal law advised us the vast majority of our clients are guilty. Your job is to make the state meet its burden of proof and get the best outcome for your client you can. Yes, absolutely. If you do criminal defense, most of your clients are guilty. That's the nature of the job. Your mission is not to make them magically innocent or magically not be found guilty of some kind of crime. Your job is to compel the state to meet its burden, to prove them guilty beyond a reasonable doubt. Member Elman says, I guess Hannah Gutierrez didn't even understand her own deficiencies. No, that's right. She didn't. Very common, by the way, in a low competence society, which is what we've become. This Dunning-Kruger effect, where people imagine that they're much more capable than they actually are. Very, very common. They can't see how stupid they are. This is especially true with the products of current day academic environments. People graduate, they're given a degree, and they mistakenly think the degree makes them smarter when it's supposed to be the reverse. The degree is supposed to be a reflection of how smart they are. But they get the degree, especially a PhD. I got my PhD. And they think that somehow makes them smarter than they actually are. Member Gino says, I find it hard to believe with live rounds found in gun belts and in the box, she didn't see it. It's not like there was just one round. They were all over the place. And member Cycle Boy notes correctly, she wasn't checking. She wasn't checking. She just assumed they were all blanks, but she didn't actually check. Member Lee Keller King says, Dunning-Kruger, 90% of drivers think they are above average. Yeah, that's true of people's own assessments of their intelligence too. 90% of people think they're above average in intelligence. Nope. Member Donna says, Donna, a female member of Law Self-Defense? I didn't think we had any of those. Welcome, Donna. Hannah was 24 at the time. You'd acted more like a 16-year-old. Yep. In World War II, tens of thousands of 24-year-olds were mature and responsible enough to serve as military lieutenants and captains. Yeah, 24 was kind of old, actually. B-17 bomber pilots and crew and faced death on a daily basis. Yes, that's all true. She does come across as like a petulant 16-year-old. Will Parker, my good buddy Will Parker. I don't understand bringing up cocaine without facts and evidence unless you will bring up the text messages regarding cocaine later. I think you have to have the text messages. To me, To me, that is the circumstantial evidence that's compelling for it being cocaine. There's no explanation consistent with non-cocaine that exists in the context of those text messages. Paul says he's changing his vote to hung jury. Why? Did you see the jury? Let's see what the poll says on YouTube. Guilty, 86%. It just keeps getting worse. It just keeps getting worse. Not guilty, 6%. Boy, there's wishful thinking right there. Hung jury, 9%. Hung juries are very uncommon, folks. I wouldn't hold out hope in a hung jury. But 9% are predicting a hung jury after the state's closing. Maybe that'll change after the defense closing. I'll have to set up another poll. I can't actually. Did you heat it up? Oh, sorry, folks. I'm talking about lunch.
I love you.
Hey, folks, I got some lunch here, so I'm going to eat a little bit, and then I'll look at comments occasionally. Maybe I'll bring that the crazy guy back up while I have a little bit of lunch until court gets back. Bring back.
Showed him on the piano how you safely decock that firearm when you get it cocked.
You wish me to pick up the gun and show how it is decocked? I would prefer first showing on a Denex to them
Yes.
and then on a live
Just
one.
show.
You're not
Don't,
gonna object, can you approach?
the cocky, if you will, using the Denex, the replica, demonstrate that the cocking and proper decocking of that weapon.
Yes. This is one of the primary things that an individual must be trained in to safely cock and decock a Colt revolver or a replica. Now, first, the finger has to stay off of the trigger and outside of the trigger guard, no matter what. That's the essential rule of safety. The firearm is cocked with your thumb.
This part drove me crazy. He said this over and over again. Your finger has to stay out of the trigger guard no matter what. It's most important. Finger outside of the trigger guard. And then he would immediately follow that by, and then you put your finger on the trigger to lower the hammer. So the finger goes inside the trigger guard as part of the operation of this gun when you're decocking it. Crazy.
You see, finger's still outside of the trigger. No one touches any trigger. This is now a gun capable of being fired. Now, the first thing I do here is put my thumb on top of it. If I'm not real strong, I put two thumbs on. Notice my finger is still completely off the trigger. I then slowly, gently pull the trigger and lower the hammer onto the cartridge. I then back it up to its safe position. Now I will demonstrate the same thing exactly with the real P8 revolver. Okay, we have P8 safely aimed.
Okay, we're back.
All right, you may be seated. Mr. Bowles?
Thank you, Your Honor. Yeah, police, court, counsel, ladies and gentlemen of the jury, I want to start also, as I did when this began, which I want to sincerely thank you for your time and attention and all of your work on this case. It's been hard. It's been a long case, and I want to thank you first. On behalf of Ms. Gutierrez Reed, who This is extremely important for her, this case, and this is her day in court. And it's extremely important that the government rule out every reasonable doubt that there is in this case, because that is our standard in this country. Reasonable doubt is a concept, meaning if you have any reasonable doubt, if you have a reasonable doubt, we cannot convict people in this country. That's how it's set up. Because of that, the burden is on the prosecution, always stays in the prosecution, and so they have to rule out all of the reasonable doubts. In this case, and I'm going to talk about a lot of the evidence soon, but I just want to start with a summary. The prosecutor just presented to you a series of pictures, and those were the pictures they paid the guy $10,000 to enlarge, and they went through the pictures and they tried to show that there were silver primers, and this is going to be definitive evidence that these live rounds had to be on set at a particular time. Let me tell you why there's reasonable doubt, number one, that they will never be able to rule out in this case. Sarah Zachary threw away rounds. She unquestionably threw away rounds after the shooting. It's undisputed. We have no idea what those look like. We will never have an idea what they look like, and that will never be able to be overcome. That one fact alone prevents that entire picture setup that was just shown to you from being accurate, from being real. Because we have no idea what those other rounds, whether they had silver primers, whether they were dummies, whether they were other types of dummies, what they look like. We have no idea. Fact two on the pictures. Seth Kenney told you he had gotten live rounds from Del Reed that went to the 1883 set. Those live rounds were three types. There were three types of bullets. He then brought back around 125 of those of the three types. Now, the ones that the state seized, the prosecutors made a point of saying these don't match the live rounds. However, we don't know what he had because they waited a month to go get him. It was over a month when they searched. And when Mr. Kenney brought in the rounds, he had been talking to the investigator about what was going on in the investigation. So we're never going to have an idea as to what Seth Kenney had and what he provided, because he also told
Folks, speculation is not a legal defense.
you in this trial, he had no inventory system. He had no idea what was coming in and going out of his place. The place was a wreck. Looked like a train had hit it. There's no way for somebody to really understand what they're putting in, what they're going out. And so he also said there were things that went onto the Rust set that he hadn't inventoried, hadn't invoiced. He said that there were things that put on there that he didn't have invoiced. So here's the problem with that. We do not know that Seth Kenney only had those patinaed rounds. That's reasonable doubt. That's coming right from the government's witnesses, from Mr. Kenney. That part is unreconcilable. There is a reasonable doubt that will never leave this case on those 2 points, on the pictures and the live rounds. Now, Ms. Morrissey calls it dishonest for us to raise a question about Mr. Kenney. And I submit it's not dishonest at all, because they have the burden to investigate every possibility, every aspect, as anybody in Ms. Gutierrez Reed's place would deserve and would want, because their life is on the line as well on felony charges, and it's the government's duty to rule out all these other things. Far from dishonest, what it is thoroughness, competence, finding what happened with Seth Kenney, taking his fingerprints, taking his DNA, going through and searching earlier, doing that investigation, and finding out if indeed there is another possibility that they ruled out right away and they never wanted to look into, because they rushed to judgment on Ms. Gutierrez Reed from the very beginning. They singled her out on that set. They put her in a cop car, whether she asked or whether they put her in. She's in a cop car and she never leaves custody until after her statement. They singled her out and they rushed to judgment on her, and that's what you've seen ever since. Miss Morrissey says, a camera crew, and she mocks things that we raise as possibilities on the idea that none of it can be possible except Miss Gutierrez Reed is guilty. That is the only thing that can be possible because I say it. It's not how it works. Miss Morrissey said she indicted Mr. Baldwin. I indicted Mr. Baldwin. Actually, I think it's the state of New Mexico. That's not an individual person with that power. She also sat there when Miss Zachary was on the stand, and Miss Zachary, I'll remind you, got an immunity agreement. Miss Zachary was promised she would never be prosecuted. And Miss Morrissey stands up and says, there's no evidence against Miss Zachary. Well, then why was she given an immunity agreement? Why would she need immunity if there's nothing against Miss Zachary? She's given an immunity agreement, and then she's told on redirect examination by Miss Morrissey, remember, if you don't tell the truth, I can prosecute you. I will prosecute you. So Miss Zachary doesn't tell the version of the truth that the government believes is true. We saw the threat in live court. You can't trust some of the witness testimony in this case, and that will raise a reasonable doubt as well, I submit, because of things like that. Because the lead investigator admits that she practiced her answers and questions with the prosecutor. That's something you can consider. Are you hearing everything? Or are you hearing a one-sided version that fits the narrative that Miss Gutierrez Reed has to be guilty because we picked her out first, and it's got to be her? Can't be Mr. Kinney, can't be anything else, any other possibilities. Sarah Zachary has nothing to do with it, even though we know unquestionably she threw away rounds after a shooting. That's undoubtedly going to be evidence, but there's nothing on her, apparently. Second, these boxes, the idea that the boxes match. We heard testimony that these rounds were loaded in and out of these boxes daily. Nobody knows what was in them on the 13th, the 16th, the 21st, because the rounds were put in, they were taken out, and they were put in different boxes. So the boxes really don't matter. There's reasonable doubt all over the place to the boxes because we don't know what was in them 3 or 4 days before. Doesn't matter who brought them. The boxes are interesting because the government wants to match up the two, and they want to show the pictures that match, yet all the ones from PDQ Props have the same label, same font. They're from Joe Swanson. So those boxes are similar to the ones on set. So that part is not conclusive as well. The other part, when the government shows you video and video and video only on the 13th, and says Miss Gutierrez Reed was lax on safety. Well, again, you're seeing videos from short snippets of time on one day on an entire movie set, and then you're not seeing what Miss Gutierrez Reed may have done right after the clip. You're not seeing what might have happened right after that. The other thing that strongly rebuts all of the safety points Miss Morrissey is pointing out about Miss Gutierrez Reed is OSHA. Now, they try to downplay OSHA, but OSHA is a separate, independent state and federal agency that did a full investigation into the responsibility for safety failures on this set. And you can evaluate the credibility in your minds of Mr. Montoya, who took the stand, and how you thought he testified, whether you thought he was thorough and how he answered questions. He interviewed quite a few people, and he reviewed a lot of information. Their conclusion after that was done was that production was responsible. He said the root cause was production adopted a safety plan, and it ended at the word adoption because they didn't do anything after that. They didn't respond to complaints that there were safety concerns. They didn't allow for more training. and take the time to do that. They did not respond to the negligent discharges and deal with that. Mr. Halls talked to one of the guys briefly, and that was all that happened. So you got to set that they're not allowing time for inventory for the armor. They're not allowing time for them to clean their weapons or deal with their weapons. This is management. You just heard Mr. Pesce state that the first assistant director is the primary person for safety on that set. Dave Halls has been doing this 30 years. Somebody doing it 30 years has a responsibility and duty to step in when there's safety things going on, and he's on several of those videos. He has a responsibility to step in and say, hey, we're going to stop this. We're going to slow this down. We're going to have meetings. We're going to have additional safety training, and we're going to address this. Ms. Gutierrez, Reed, come over here. We're going to do this, and we're going to talk to people. She also can come in and talk about that. And on those videos, they're both on the videos. But OSHA found, because of the lack of support, because she's a part-time armor, because she's not full-time, because there's not two of her, as Mr. Carpenter said, 2 is 1 and 1 is none. Well, here we didn't even have 1. We had a half. So she's trying to run around and do various things. She's a half a job on a set with over 20 guns, and they want to lay the complete blame on her in this case, as opposed to OSHA, who investigated as an official agency and made an official determination that this was production and management that was responsible. That's important. That's an important finding, because they said all of this was caused safety-wise by management.
All of this closing by Bowles works only if the jury's as stupid as he is. If that's true, he may win.
As Mr. Sousa told you, the buck stops with production. The buck stops with production. As in any organization, it starts at the top. You don't go and take one of the lowest people on the call sheet after something bad happens, after the whole management team is just thrown safety aside in favor of money, in favor of speed, in favor of profit. You throw all of that aside, because at the end, you've got a convenient fall person. You got a convenient scapegoat. And she may not be the armor on some days. She's a props person, but she's certainly the armor when everything goes bad. You know why? Because despite OSHA's findings that they were responsible, production, the guys that you saw come in, the producers, the big guys, they want to sail off into the sunset and go on about their business, finish the movie, make the money, because they've got the convenient fall person sitting right here. And all that has to happen is everybody has to gang up. Everybody has to have their talks after this happened and blame Hannah. So it has to happen. That's what happened in this case. You had a production company on a shoestring budget, an A-list actor that was really running the show. He was directing people in those clips, telling the camera person where to go, telling the armor where to go. And then you had a situation where at the end, they had somebody they could all blame. It didn't work out with OSHA because OSHA didn't buy it. OSHA said it was the higher ups. So here we are in a criminal court where the government tries to pin all of it on Ms. Gutierrez Reed. And it's just not the truth. It's absolutely right. We do want the truth. We want the truth and all the facts that were found by OSHA to be considered. We wanted all of the facts that you don't have in this courtroom to be considered, because that's the only fair way to do it, to resolve all reasonable doubt and to rule it out. If you don't have all the evidence, you can't rule out all of that reasonable doubt. I want to talk about foreseeability, and I want to play this for you.
By the way, there's not a criminal prosecution in the world where you have all the evidence, like the universal body of evidence. That's not a thing.
You probably remember that. That was the scene where Mr. Baldwin runs up the hill and cut is yelled. And right after cut is yelled, he shoots. That's, I submit, reasonable doubt, and I'll tell you why. Because Mr. Baldwin went off script. He chose to fire after cut was called. And you're going to see where he does later do the same thing in this tragic shooting. Mamie Mitchell told you on the stand, the script supervisor, that it was not in the script for Mr. Baldwin to point the weapon. It was not in the script for him to point the weapon. And we have to be very careful with facts when we're considering a criminal case and the beyond the reasonable doubt standard. That's extremely important because Ms. Gutierrez Reed, nor anybody else, knew that Mr. Baldwin in that moment was going to point the weapon right at Halyna and Ms. Hutchins and Mr. Souza and do what he did. That is the concept of foreseeability. Now, Ms. Morrissey gave you an example of if I hand somebody a firearm and it's loaded and then they go and do something with it and it hurts somebody. But here, what we had, she did not know Mr. Baldwin was going to do what he did. No one, first of all, called her back into the church that he was using the gun at that time. She had given it to Halls to sit in the church. Mr. Halls then gave it to Mr. Baldwin, and that is the conclusion of the lead investigator. That was what Baldwin said, and that is what Ms. Gutierrez Reed said. So Halls hands it to him. No one calls her back in to let her know Baldwin is doing that blocking scene. She doesn't know that's happening. The medic said she did not hear anybody call that out, first team, over the channel. So that's not getting put out. So Baldwin's doing another audible like he did on this video that you just saw. He's going off script. That defeats any idea that that was foreseeable to Ms. Gutierrez Reed. If she doesn't know what's happening, she can't foresee it. That's a big part of the instruction.
No, that's not what foreseeable means. Lots of things could be foreseeable, but only one can happen at a time, right? It doesn't mean the other things were not foreseeable.
The other part I want to talk about foreseeability and where this matters is live rounds. Now, live rounds in this type of situation has not happened in Hollywood. In the 100 years of Hollywood, this has not happened in a situation like we saw in this case. No one on that set foresaw, knew, or thought that live rounds were going to be on that set. No one. You did not hear one witness in this case. Even Ms. Morrissey said there was no evidence that Hannah knew about live rounds coming on or this was done. There's no evidence of that. Nobody thought live rounds were going to be on set. Mr. Souza told the doctors he couldn't believe it. He argued with them because it was inconceivable that live rounds would appear. Because of that, when you read the jury instructions, there's a concept in the involuntary manslaughter of an element of willful disregard of the rights of another. That word willful, and I'm going to go over it soon, means purposeful. That you willfully do something, you purposefully do something. What's impossible for the government to prove in this case.
As usual, Jason Bowles is being very fast and loose with the legal terminology and his claims of fact and what Morrissey said. I don't think he's doing it on purpose. I just think he's not very bright.
Ladies and gentlemen, I'm going to talk about willful more in a moment when we get there, but it cannot be willful if Hannah does not know there's live rounds, and nobody did. So she did not do something willfully, knowing that Baldwin could foreseeably hurt somebody with this firearm, because she didn't know it was live. And let me give you an example. It's akin to a nurse, let's say in a hospital, who the pharmacy mislabels a drug. And let's say it comes to her and somebody's ordered it be administered to a patient. She then administers it not knowing that is a fatal drug of some other type. The pharmacy's mislabeled it. The patient passes. It's the same situation as we have here, where the government would be saying the nurse committed involuntary manslaughter. No, that's not true.
Oh my God, the guy's just not bright. He's just stupid. So let's take his analogy. The pharmacy mislabels a drug, gives it to a nurse, the nurse administers it, and it turns out to be the wrong drug. That is Hannah preparing the gun, giving it to Alec Baldwin, and Alec Baldwin uses it and somebody dies. By his own analogy, the pharmacist is his client, Hannah Gutierrez, who prepared the drug or gun wrong in a lethal fashion, and it was someone else's innocent mistake that caused the harm. Jeepers.
Because she did not know what happened. It's like a long time ago when the Tylenol capsules were laced with cyanide, way back in the 80s or somewhere around there. There was no prosecution of the pharmacies that didn't know about this, that were tainted by it. It's the same type of situation we have here with the nurse. Miss Gutierrez Reed did not know there were live rounds, and she was entitled to rely on production buying dummies and the boxes labeled dummies. She's entitled to rely on that, and that reliance is reasonable. So she cannot foresee a live round. Now, I want to talk next about Miss Gutierrez Reed's statements to law enforcement. You saw her first statement. She didn't have an attorney. She did waive her rights and answer her question. She had not been advised at that time. Ms. Hutchins had passed. And she came in a second time and answered all questions. The reason why I say that is she was cooperative. She was trying to assist in what this investigation, what they were investigating. Now, Corporal Hancock never fully investigated the source of the live rounds. And she told you that she focused on people on the set. So again, in ruling out reasonable doubt and where those live rounds came from, we have not done that in this case because there was never a full investigation as to the source of the live rounds. Let me give you an example. The state never called Joe Swanson. And it's kind of remarkable because Joe Swanson was the original source of where these came from. He's also the JS on all the boxes. So the idea that the person where it originated, you wouldn't call that person and get some more information is interesting. But more than that, it leaves a huge hole in the origin of the live rounds. Let me tell you what else it did.
Who else didn't call Joel Swanson as a witness? You!
Seth Kinney's fingerprints and DNA were never taken. Seth Kinney talked to Corporal Hancock 40 times or more. They supplied information back and forth. And he starts making you wonder about what's going on and why I'm called dishonest for raising the possibility that maybe Mr. Kinney was the source, because he's pretty tight with law enforcement in this case, obviously. They don't do a prop search warrant until 6 days after the incident, and that was Corporal Hancock and the rest of the sheriffs. They don't search Mr. Kinney's business until over a month after. They never asked the FBI to check live rounds for fingerprints or DNA. And so we will not know if Mr. Kinney's fingerprints or anybody else's would have ever appeared on those live rounds on set because they didn't get that evidence. Bryce Ziegler, I want to tell you a little bit, remind you a little bit about his testimony, and that's Mr. Ziegler. He talked about Baldwin's revolver being single action. You have to cock it, and then every time you want to shoot it. He testified about breaking that firearm. They actually destroyed the firearm after testing that was approved by the sheriff by hitting that with a hammer. He talked about that you can't determine a live round from a picture. And that's the other point I think is important to consider when considering the picture analysis. Now, the Latin print examiner, examined various things, but she did not examine anything Seth Kenney wise. There's no analysis on the cartridges from the prop cart, and found 8 FBI employee prints. Mr. Gillette, on the powder testing, only tested 11 rounds from Seth Kenney. Again, we know that he brought back 125 from the group that went to 1883. And I also want to remind you about 1883, some of those were Starline brass rounds. And some of those, he said, had silver primers. So when we get to the set, the live rounds are Starline brass, and they have silver primers. It's a continuous chain that could have been traced from Del Reed all the way to Seth Kenney, all the way back to the set. But they did not do that thorough investigation, and that's reasonable doubt they have not ruled out.
The source of the live round is irrelevant to the involuntary manslaughter charge. It doesn't matter. It doesn't matter where it came from. What matters is a live round was in the gun, regardless of the source of the live round. Smoke and mirrors.
The dummies, again, I submit this is another area of reasonable doubt. Witnesses testified this set contained a dangerous mix of dummies. They were dangerous because it was impossible for the armor and prop master to hear and rattle all of the dummies, especially under pressure, rushing, and noise on the set. You saw there was a lot of wind that day on the lapel. There's people running around. There's, I think at one point somebody said 200 people. There's all kinds of things going on. And despite that, Mr. Haig indicated in a quiet office he could not hear one of the dummies when it's rattled. That's dangerous because when you're trying to do it quickly, when there's a lot of noise, it may be a dummy. It may not. You can't hear it rattle. Seth Kenney, again, mentioned.
Let's pretend this is true. If you pick up a round and you shake it and you don't hear a rattle, so you can't tell if it's a dummy or a live round, do you put it in the gun?
In this case, that he always rattle tested his rounds and he made sure they're dummies. He told you all that. Well, the problem, even the box that they say was Seth Kenney's and the rounds that came out of it, there was one round, if you remember, that was gunked and it didn't shake. That round had to be sent to the FBI to be broken apart and to be checked to see if it was live. So if he truly is that thorough in shaking, he missed that round. Now the producers, they had oversight over the budget team. They didn't know where the funds were set aside for the armor. They were on location for filming, and they were fined the statutory maximum by OSHA for managerial safety violations. Again, OSHA found that the management team are the ones responsible. And yet we're here with Ms. Gutierrez Reed, the person on trial for the felony offenses. Sherilyn Schaefer was the medic on set. You recall she did not have chest seals. She, I think, was doing the best she could with the equipment that she had, but she didn't have the complete equipment to deal with a gunshot wound. She also indicated she never heard anyone call out use of a gun before the fatal shooting. Mamie Mitchell, I touched on this earlier. Most important thing Ms. Mitchell said was that it was not in the script for Baldwin to point the firearm. That goes directly to the element when you read the jury instructions and you all go back in to deliberate. that goes to foreseeability and whether or not anybody can foresee the moments Mr. Baldwin pointing the gun, using it as a pointer. He's up on the hill shooting after cut, and then he's shooting, pointing the gun when he's not supposed to in scenes. David Halls was the first assistant director, as you remember, and he was in charge of overall safety. Now, he got a misdemeanor, 6 months unsupervised probation, even though he was in charge of overall set safety. He never raised any concerns. And in fact, I think he said Hannah did a great job as armor. He indicated he did not hand the gun to Baldwin.
This is where it would have been helpful for Kerry Morrissey to have asked each of those witnesses who said, I thought it was safe, I thought Hannah was safe, to ask each of them on redirect, well, you thought she was safe before Halyna Hutchins was killed. Would you say your opinion changed after Halyna Hutchins was killed by a gun that Hannah Gutierrez prepared for set?
But the sheriff contradicted this, so did Hannah, and so did Mr. Baldwin. And that was essentially Mr. Hall's testimony. Sarah Zachary, I remind you, she threw away rounds on set after the shooting, took items off the prop cart. She worked for Seth Kenney, and she texted and called him right after the shooting. One of her texts, she indicated she had said she was talking to Alec Baldwin and trying to keep her facts straight. She mentioned that she had loaded firearms on set. She picked up ammunition from Kenney at PDQ. I'll remind you in the testimony that Sarah Zachary and Hannah Gutierrez Reed went to Kenney's place before production started, and he had given them ammunition, leathers, and firearms. So again, we don't know exactly what Mr. Kenney may have supplied to this set because it's not inventoried, it's not all invoiced. I also remind you about Sarah Zachary when you're considering her credibility and her testimony. She had the text where she wanted Hannah to go to jail, and she's given complete immunity. Seth Kenney, again, I mentioned this, he supplied the leathers, guns, and ammo before arrest began. He had no inventory system. And we attached some pictures to the right that you can look at in the jury room about his place. It was an absolute mess. There was stored live ammo in the bathroom. And one of the things I think was important to remind you of is he actually called Joe Swanson and had a conversation with him. And after he gets off the call, his first words are shit, shit, shit. And so that's something as an investigator, you would think after he does that, maybe I should call Joe Swanson and see what's happening, see what that means. That reasonable doubt has not been ruled out. I went over this on the 1883 set, and he brought 125 rounds back. Mr. Carpenter, I want to remind you, he was the state's expert armorer. One of the most important points he said was 2 is 1 and 1 is none. And here we didn't have a properly staffed armorer component to the set. Luke Haig, he said the live rounds on set were reloads. He could not hear the dummy rattle in the quiet office, and he said Mr. Baldwin violated basic safety rules. Karen Kuhn, you may remember, was the photographer. She said the armorer was checking guns before when she was present. And she also made a comment about Mr. Baldwin that on the day she was taking questions, I believe she said on the 21st, he told her to get out of his personal space and said something in a manner that kind of goes along with how he was on the set. Mr. Souza was kind about it. He said he had a strong personality, but you can see it in the videos, and you can see how Mr. Baldwin was acting. Rebecca Smith, I want to talk about the tampering. She said that she hadn't used cocaine in 31 years. She saw a baggie inside a baggie for approximately 5 seconds. She didn't know if it was cocaine or meth or something else. Now, she admitted at the end she was guessing. And we also know that the substance in the baggie was never tested. And so the only evidence you have of narcotics in this case is a guess. Now, Ms. Morrissey in her closing indicated that, well, of course we don't have the evidence. The whole thing is throwing it away. Well, you have to prove first that it was evidence. So in a normal tampering case, when, let's say, a firearm's thrown away, and we know a firearm was used, and somebody throws a firearm away, we know that was a firearm. So we know that would be evidence in a case involving a shooting. Here, we have an unknown substance. Again, they have to rule out all of the reasonable doubt by that. It's not enough to say it's probably something under a criminal standard. It's probably cocaine in that bag because Ms. Smith says it is. If it even happened, we don't even know this happened. The government hasn't established that except through her testimony. We don't know if there was a bag. We don't know if this actually was passed. And that's their burden. Let's say it did happen, that you believe it did happen. It's not enough to say what was probably in that bag. They have the burden to rule it out beyond a reasonable doubt that it couldn't have been anything else. And she's already calling it in her testimony potentially multiple substances, cocaine, methamphetamine, or possibly something else. So she's not even certain about what it is. Without a test, without something presumptive to tell you on a test, there's no way of telling what was in that bag. And it's not enough in a criminal case. OSHA, we talked about in detail, and I just want to remind you the root cause they found, they attributed all the responsibility for safety issues to management. Mr. Elliott, he was defense expert investigator, got an extensive law enforcement experience, if you recall, in APD and military. One of his big points was Mr. Baldwin was not segregated at the beginning, even though he was the known shooter. Hannah was segregated right away. Again, they zeroed in on her in the rush to have her identified. He indicated there was 20 or so key witnesses not identified and segregated. And the problem with that is they can get their stories together and they can change their stories. They can have their memories altered. We know this happened in this case because after the incident, Mr. Baldwin is talking to Sarah Zachary. He's texting and talking to her. Seth Kinney's talking to Sarah Zachary. Mr. Halls is talking to Baldwin after. And so we don't have all the information they're talking about, but we do know they're coordinating, they're talking. The only one not in that group was Hannah. And again, this was the idea. We've got to circle the wagons and we've got to pick out the person that's going to take the fall for everything that's happened here. That's Hannah. That's who they got. Law enforcement failed to follow up on the origin of the live rounds, and their delayed search warrants caused problems with missing evidence. PJ Pesce testified just this morning. He had said, like everybody else, he's never seen in 35 years an armor split duties with props. It's not possible for one person to keep track of so many firearms. And he indicated it's important to give the armor adequate time and resources, which OSHA said as well. She was not given that to do her job. I want to talk to you about the law that the judge instructed you on, and that is the law. What the judge told you about is what we have to follow in terms of evaluating this. The law presumes the defendant to be innocent. The burden is always on the state to prove guilt beyond a reasonable doubt. A reasonable doubt is a doubt based upon reason and common sense. The kind of doubt that would make a reasonable person hesitate to act in the graver and more important affairs of life. A doubt based on reason and common sense. So what the government has to do is rule out every reasonable doubt you may have based on reason and common sense. Or in this country, we don't convict people. That's the standard. And again, I go back to where I started at the beginning. If they didn't rule out the reasonable doubt on Miss Zachary throwing away the rounds, that is always going to be there. Because their theory based on you can identify these pictures and we know exactly what was on the set and what remained on the set, and what we will never know that because some of them were thrown away. And we didn't get all of Seth Kinney's rounds. We're never going to know that. Other areas of reasonable doubt, I've gone over the top 2, top 3. The prop cart was tampered with. We know that right after the incident, another individual moved it. Now, Lieutenant Benavides said he had eyes on the entire time. But if you saw that video, you can make up your mind what you believe. Ladies and gentlemen, his camera appeared to be pointed right into the vehicle, and the individual getting the cart was way off in the other direction. He said he had his head turned, but you all can decide what you think about that. The prop cart, there was unquestionably items taken from it. We don't know exactly what those are. That is another area of reasonable doubt that the government has not ruled out. You've had witnesses say throughout the trial, you can't tell live ammo from a picture. And the reason is that the FBI said it has to be disassembled and you have to open it up because there's powder in it. If there's not powder in it, then it's not live. OSHA stated the root cause of all safety failures was management. OMI ruled this to be an accident, not a homicide. You heard evidence about the esophageal intubation was ineffective to provide oxygen to Halyna. This also was a situation in this case where multiple lawsuits have been filed, and you can evaluate their testimony, those people who have filed lawsuits, with care and caution, because they've got an interest potentially in what's happening in this case by being involved in lawsuits. Involuntary manslaughter, you're going to have that instruction when you go back. That is the charge that Her Honor has read to you. She's given you the law on this. I want to focus you on a couple key points. The government has the burden to show each of these elements beyond a reasonable doubt. The elements are the numbered items. What that means is if you all have reasonable doubts on any of these elements, Hannah cannot be convicted. And I want to focus you in on element 3, that Hannah acted with a willful disregard. Again, you go back to willful disregard, the nurse example, and the idea that if somebody doesn't know, I mean, that could be the same thing with a nurse on trial for involuntary manslaughter, but if she doesn't know the drug was mislabeled, you cannot hold her criminally accountable for something like that. It's the same thing in this case because no one knew there were live rounds. So she did not act willfully in anything that happened that day. In loading the firearm, this was another day everybody thought on set. Loading the firearms, running to different things, doing the duties. Nobody's calling her back in for the blocking scene. Mr. Baldwin's doing something on his own. Nobody in the wildest dreams thought there was a live round. And because of that, the next element is that Hannah Gutierrez Reed that caused the death. I submit to you that what caused her to pass was Mr. Baldwin going off script and pointing the weapon. Now, he didn't know there was a live round in there either. He didn't know. Again, he's in the same position that nobody knew there was ever going to be a live round on that set. But the only ultimate act is pointing of that weapon. Miss Gutierrez wasn't in the church. She didn't point that weapon. She didn't pull it. Nobody called her back in. And because of that, those two elements, I submit to you, have not been proven on involuntary manslaughter. And they have to be. The government has to resolve all your reasonable doubts about that, or we cannot convict. Mental state and willful disregard, and that is going to be in your instructions. For you to find the defendant acted negligently in this case, you must find that the defendant acted with willful disregard. And so again, that's the terminology, is willful disregard.
What's that mean?
You're also going to be instructed, the court instructed you, Her Honor, on negligent use of a firearm. And that is a lesser included offense of the involuntary manslaughter. So when you go back and deliberate, you will have this in front of you as well, whether Ms. Gutierrez Reed endangered the safety of another by handling or using a firearm in a negligent manner. And again, the language is acted with willful disregard. That's what has to be proven under that charge for you to resolve all of your reasonable doubts. Tampering with evidence, I think this is a real stretch, and it is a real stretch. And you talk about guessing. This one, they have to prove the defendant hid a bag of cocaine. Well, the only witness they have to it said it was either cocaine or meth or something else. So just by the testimony alone, the beginning of that, there's no way of knowing it was a bag of cocaine. It's just impossible. There has to be reasonable doubt on that by the government's own witness. Their only witness. No law enforcement testing. There's nobody else. This is absolutely unproven in this case. And you don't even have to get to element 2 because element 1 is not even close to having been proved beyond a reasonable doubt. Proximate cause, it's a legal term, but it's something the government has to prove as well. And this is where you get into that the passing was a foreseeable result of Hannah Gutierrez's act. The act was a significant cause of the death, and the language I want to focus you in on, in a natural and continuous chain of events uninterrupted by an outside event. What these mean, and these are the legal terminology, what it means is that what Hannah Gutierrez did had to be a foreseeable result, but again, that caused her death. But again, without her knowing that there was a live round, that's impossible to meet that standard. She did not have that knowledge, and there's no witness that came in here in this courtroom in 2 weeks to say she had that knowledge. Without it, nothing she did. She has that willful disregard because she just doesn't know. Now, was there an outside event as well? There was an outside event. There's 2 outside events. Whoever put the live round on set, and then Mr. Baldwin in the end going off script and doing what he did. Those are outside events outside of Miss Gutierrez Reed's control that she didn't know was going to happen. That breaks any idea, and there's reasonable doubt that she had anything to do ultimately with Halyna Hutchins' death. Miss Gutierrez Reed was not a significant cause as a result of her death because of the reasons I've mentioned to you. Another instruction Her Honor gave you is that negligence of a third person, again, I'm going to highlight the language, if it breaks the foreseeable chain of events. Again, the foreseeable chain of events on that set is you have dummy rounds, you have blank rounds, and then you have an orderly progression with how those are being used. Here we had a completely unforeseeable live round, 6 live rounds that were on set, nobody could foresee. And then we have Mr. Baldwin's action in the end. Those were both unforeseeable to Miss Gutierrez Reed. The judge instructed you all are the sole judge of the facts. You all are deciding the facts, ladies and gentlemen. And your verdict should not be based on speculation, guess, or conjecture. It goes back to the tampering charge. It goes back to some of the other aspects the government has told you. In this country, we can't decide and convict people on guesses. And that's a lot of what they've asked you to do in several areas, to guess, to assume, to speculate. It's not sufficient to convict people in this country to guess. It's not. And that's what they brought you and they've asked you to do on the tampering and other aspects of their charges. And that's not sufficient. Ladies and gentlemen, Hannah is not guilty on all the counts because of the law that Her Honor has given you. when you apply that law and you apply the standard of beyond a reasonable doubt. She could not anticipate what Baldwin would do. It was not in the script. It was not foreseeable. Management was responsible for safety failures and not Hannah. There's zero evidence of cocaine. There's no testing. And again, I go back to the idea that Hannah is a scapegoat for all the management failures. They do hope she gets convicted, so they're all exonerated. They can move forward. They can finish that movie like Mr. Sousa said they did and make their money. But as he also told you, the buck always stops with production, and it's their responsibility. In any organization, it goes from the top down. And that's where the responsibility lies in this case. That's what OSHA said. And that's also the truth. And the truth is important because justice for Halyna does not mean injustice for Hannah. Does not mean injustice for Hannah. It does not mean they get to steamroll her and they get to come in and spin their version of facts and they get to call it truth. Because that's not truth. Truth is bringing you, ladies and gentlemen, everything they can. Justice is bringing you everything they can. Justice is not mocking theories that could come true, that might have been the case. Justice is not laughing in court during some of our exchanges. And you can evaluate that as to their credibility, whether that was professional, whether if she didn't take court seriously, did she take the investigation seriously? I submit she did not. And so they can't come in here with a straight face and mock us and criticize us and tell you they have given you enough to convict her behind a reasonable doubt, because they haven't. Thank you.
State's reply.
Morrissey on rebuttal. Well, if he gets a stupid enough jury, it might work. According to him, Hannah Gutierrez had nothing to do with this death. No role whatever.
I'll begin while the gentlemen are setting up the Elmo for me. Hannah didn't know there was a live round on set. I agree. If Hannah knew there was a live round on set and she loaded it into a prop gun and it was used to kill Halyna Hutchins, she wouldn't be charged with involuntary manslaughter. She'd be charged with second-degree murder. She'd be charged with first-degree depraved mind murder. This is an involuntary manslaughter charge because she didn't know there were live rounds on set, and the reason she didn't know was through her own negligence, her own recklessness, her own willful disregard for the safety of other people. That willful disregard, that lack of care for the safety of other people that you have seen throughout this trial, it is shocking. For Mr. Bowles to come up to this podium and say it wasn't foreseeable that Alec Baldwin was going to go off script and pull the hammer and pull the trigger. He showed you a video of Alec Baldwin going off script. Alec Baldwin went off script. Hannah Gutierrez knew it. She was there. Hannah Gutierrez knew that Baldwin was loose. She knew it. She didn't do anything about it, even though it was her job. It was her job. It is her job to say to an A-list actor, if in fact that's what you want to call him, hey, you can't behave that way with those firearms. That is her job. That is what they pay her for. That is the job that she applied for. That is the job that she accepted. Foreseeability. You want to talk about off script? Just remember those videos of the stuntman. That's not within the script. She was there. She watched it. She knew these people would go off script. You know she didn't check the rounds. If she checked the rounds, they wouldn't have been floating around that movie set the entire time, undetected. Give you everything we've got. You have absolutely everything we have. This law enforcement team and this team of prosecutors have reviewed thousands and thousands and thousands of photos and thousands of videos. We have interviewed countless people, many of whom you didn't even hear from. We can't stay here forever. You have absolutely everything you need. One of the amazingly shocking things about this case to me has always been, and it's to Detective Hancock's credit, a defense attorney with his own agenda, no question, comes to her and says, it's Seth Kenney, it's Seth Kenney, it's Seth Kenney. That's his job. Okay, let's make that clear. That's Mr. Bowles' job. He gets Hannah's dad to say, it's Seth Kenney, it's Seth Kenney, it's Seth Kenney. Rather than ignore them, she gets a search warrant. She took his speculative agenda, presented it to a judge, got a search warrant, and searched that man's property. And oh my heavens, what did they find? They found exactly what Thel Reed said they would find. They found live ammunition with semi-wad cutter projectiles. You have everything you have. You have everything we have. You have everything you will ever need to convict her. This is 100% foreseeable. Hannah Gutierrez is not a scapegoat. Hannah Gutierrez is not being treated as a scapegoat. Mr. Halls was charged criminally. To his credit, he took an early plea and he got the benefit of that. Mr. Baldwin has now been indicted. Everyone with criminal culpability has been criminally charged in this case. She's not being scapegoated. She is being treated like everyone else. She is not being given a break because she's a woman. She is not being given a break because she's young. Because that's not how the law works. Let me just review my notes real quick. And as I promised you, I am going to try to speed this up for you. Please keep in mind, Mr. Bowles comes up to the podium and says Sarah Zachary threw rounds away. She did. Obviously she did. She admitted it. She told law enforcement that she did it. And rather than try to prosecute her for tampering with evidence, for panicking and throwing some rounds away, she agreed to come in and testify, and her agreement is that she must testify truthfully. And she testified truthfully. You want to know why we don't have an inertia puller in evidence? Why we don't have a box of dummies that Ms. Gutierrez said she brought on set? She said she brought 2 boxes. We've only got 1. You want to know why? Because she went to the prop truck on October 23rd, got access to it, took a bunch of gun belts and a couple of boxes.
Your Honor, I'm going to object.
Well, well, well. Well, Bowles did a lot of misstatement of the law is perhaps a little bit too strong. Obviously, stretching the law as far as he can in the interest of his client.
Where were we? She took stuff out of the prop truck. She took gun belts. You heard from Sarah Zachary that those were gun belts that she brought from another movie set that were already loaded with dummy rounds. Who knows what was in them? So I want to make sure that we understand what reasonable doubt means. Reasonable doubt means the doubt must be reasonable.
Good.
It is not a reasonable doubt to cast suspicion on Brian Norvell. It is not a reasonable doubt to cast suspicion on Seth Kinney. All investigative leads were exhausted. He simply didn't do anything wrong. You want to talk about scapegoating? That's the guy that got scapegoated. The doubt must be reasonable. And I don't have to prove this case beyond all possible doubt. If that is what the law required, my heavens, we live in a world of infinite possibilities. The government would never be able to prove a case beyond all possible doubt. We'd have to have a video of absolutely everything that took place. It's not the standard, and it doesn't have to be the standard. So when you're back there and you're talking about doubt, make sure it's a reasonable one under this set of circumstances. You know, Mr. Bowles says to you, these production outfitters were just from one day. That's right. All that happened in one day. Imagine what all the other days were like. That was one day. Mr. Bowles is right. The crew didn't believe there were live rounds on set. They believed that she was going to do her job. They believed that she did her job. This isn't Seth Kinney's responsibility to inventory rounds, although he did it. That wasn't his responsibility. Rust Productions didn't provide all of the dummy rounds to the set of this movie. You know from her own statements she brought 2 boxes on herself. We're not living in an alternate reality. All right. Let's go through these. I'll go through them relatively quickly. When
Jury-
you all go back into the jury deliberation room, you will have your own copy. So you certainly will have a copy to reference. These are some of the instructions that are important to us. Your verdict should not be based on sympathy or prejudice. Sympathy or prejudice? Huh? Oh. Oh, I see. There we go. Thank you, Mr. Lewis. So it can't be based on sympathy or prejudice. And for any of you who are feeling sympathetic because she is young and she is maybe inexperienced, although by her own statement to Detective Hancock, she would tell you she wasn't. You all are on this jury because during voir dire you agreed to follow the law. And I will ask you to do it right now. If you had said during voir dire, I can't follow the law, I feel too sympathetic, you wouldn't be here. And if you can't follow the law, you can probably excuse yourselves. I'm going to skip that one. That's an easy one. You must not concern yourselves with the consequences of your verdict. That is the law. That is the law that you agreed to follow. That is the law that you are required to follow. Hannah Gutierrez endangered the safety of another by handling or using a firearm in a negligent manner. There can be absolutely no doubt. That happened. Hannah Gutierrez should have known of the danger involved by her actions. Yeah, she knew. This was completely foreseeable. She was trained in firearms. She knows what we all know. Guns can kill you. You gotta be really careful. Her act caused the death of Halyna Hutchins. (12A) is the alternative theory. And so let me explain to you that 12 and 12A are alternatives. You must make a decision about guilt or innocence unanimously to the count, not to the alternatives. So 6 of you can say, I think she's guilty of 12, but not 12A. Another 6 of you can say, we think she's guilty of 12A, but not 12. Done. You're done. Hannah Gutierrez loaded live ammunition into a firearm. Yes, she certainly did. She told the police she did. She failed to perform an adequate safety check of the ammunition. Of course, you know that. She didn't do it just once. She did it numerous times. She acted with willful disregard for the safety of others, without question. So you are being presented with what's called a lesser included offense. And I will remind you the instructions that the judge read you at the beginning. Your first job is to see if you can agree on involuntary manslaughter. If you find her guilty of involuntary manslaughter on either alternative, you do not move on to this misdemeanor. It's done. If you find her not guilty of involuntary manslaughter, then you get to move on to the misdemeanor. You've heard a lot about that. I'll skip it. This is what we call a general criminal intent instruction, and I want to just make sure that you understand this instruction only applies to the tampering with evidence. It does not apply to the involuntary manslaughter because she is charged with negligent homicide, not intentional. Very importantly are the proximate cause jury instructions. These jury instructions are what allows you to find Ms. Gutierrez guilty, even though Mr. Baldwin may have also been a significant cause of the death of Halyna Hutchins. So let's go through it. The death was a foreseeable result of Hannah Gutierrez placing a live round into a firearm. Of course it was. The act of the defendant was a significant cause of the death of Halyna Hutchins. The defendant's act was a significant cause of death if it was an act which, in a natural and continuous chain of events, uninterrupted by an outside event, resulted in the death, and without which the death would not have occurred. She brought a bunch of live rounds on set, accidentally, but negligently. She loaded one of them into a prop gun, and this was after they were loaded into Jensen Ackles' gun belt and Alec Baldwin's holster. And she told Dave Halls, this is a cold gun. He told the crew, it's a cold gun. At that point, everyone certainly assumed that there wasn't a live round. She knew Baldwin would go off script. She didn't have prop duties to tend to. She walked out. And even if she had been there, it wouldn't have made a difference, because you have seen the incredible lack of control that she exercised as the only person on the movie set in charge of firearms. There is no intervening event. If you think the intervening event is that Baldwin manipulated the gun, that's the whole purpose of the prop. He's going to manipulate it. You saw a bunch of other actors do it. Very importantly, there may be more than one significant cause of death. If the acts of two or more persons significantly contribute to the cause of death, each act is a significant cause of death. If you think Baldwin's act was a significant cause of death, that's okay. You can still convict her. Jury instruction 20. If you find the negligence of a person other than the defendant was the only significant cause of death, or constitutes an intervening cause that breaks the foreseeable chain of events, the defendant is not guilty. Well, that's not this case. She brought the live rounds on set. She put a live round in a prop gun. That's the reason that Ms. Hutchins is dead. One of at least two reasons. I will again thank you very much for your time and for your attention. I know that this has been hard work for you folks. I will ask you to find Ms. Gutierrez guilty of involuntary manslaughter and tampering with evidence. And I will ask you to bring some justice to Halyna Hutchins. Thank you.
All right, thank you. Instruction number 22, I will now ask you to retire to the jury room to begin your deliberations. You will be provided a copy of the jury instructions, and the exhibits introduced as evidence will be made available to you. Prior to beginning your deliberations, you will need to select one of you to act as foreperson. That person will preside over your deliberations and will speak for the jury here in court. Forms of verdict have been prepared for your use. You will take these forms to the jury room. When you have reached a unanimous agreement as to your verdict, the foreperson will sign the forms which express your verdict. You will then return all forms of verdict, these instructions, and any exhibits to the courtroom. There are 12 that deliberate. There are 4 alternates on this jury, given the long length of this jury. Keeping with the privacy, I'm going to pass this instruction down with the help of Ryan, you're going to look if this is one of your names and you are one of the alternates. What I'm going to ask the bailiffs to do is to first take the alternates out so they can get their belongings. And I'm going to ask you to meet me down at the end of the hallway to explain. I hate to tell alternates they're alternates because they've been paying so close to the evidence. And so just to talk with you, and then and thank you. And then right along on your clip will be the jurors themselves. Okay, and the jurors will go into the room. So I'll need the aid of both of them. But first, let me pass this piece of paper over to you. Look down here. There's 4 names. See if one of them is yours and you're an alternate. It's at the bottom.
All right, we've heard all the closing now. Last poll, last verdict poll up on YouTube. Members, I can't do a poll on the member page. Sorry, just stick there in the comments. What do you think? Guilty, not guilty, or hung jury? Now that we've heard the closing of the state, the closing of the defense, and the rebuttal by the state. I thought the judge has been fine for this trial. Good control of her courtroom. You hardly even notice her, which is kind of what you want from the judge. And folks, if you're on YouTube, hit that like, thumbs up button. There's 2,300 of you here.
All right, so follow
645
the alternates
5%.
follow Ryan. I'll meet you down at the end of the hallway after you get your belongings, and then you'll follow with the jury.
And subscribe. Hit that subscribe button. The consensus of the Law of Self-Defense members is guilty AF. I should have asked about the tampering charge separately. That's hard to do in a poll. I don't really care about the tampering, but I could understand a reasonable jury finding guilt beyond a reasonable doubt. I wish Terry Morrissey had brought up the text messages. She never brought up the text messages.
All right, we're in recess. I'll be back in, but we're in recess. You can get going with your exhibits and things like that.
Okay. Going to turn to questions, comments. By the way, with all of you here, I might mention you might be interested in getting a free copy of my best-selling book, The Law of Self-Defense Principles. That's this book, folks. This book, your handbook to being hard to convict. If you're ever compelled to defend yourself, your family, your property, I give this book away for free, a real physical book. You just have to go to lawofselfdefense.com/free book. Explains everything about use of force law. Easy to read, plain English. Check it out on Amazon. 5-star rated. Many, many reviews. But don't buy it on Amazon. They will charge you $20 or $25 for the book, plus shipping and handling. We only ask you to cover the cost of shipping the book to you. lawofselfdefense.com/free book, or scan that QR code right there on the screen. Now's your opportunity while you're all here. All right. So, by the way, this whole notion that it was unforeseeable that there would be a live round on the set is patently false on its face. If people believed it was impossible for there to be a live round on the set, why do we have all these steps for listening to the rattle and for drilling a hole in the case? Why would you do that if you didn't actually have to be concerned about a live round? We do all that because we recognize it is possible for a live round to be on the set. Exactly the opposite of what the defense is arguing here. And Kerry Morrissey should have said that on closing too. A little disappointed there. Okay. It's too bad defense counsel doesn't give refunds. John says on the law of self-defense. I've heard that he was working pro bono, so there may be no refund to give. I don't know. Yeah, let me change my banner here to Verdict Watch. Whoops. Blew it. Okay. Verdict Watch. There we go. All right, let's see. The court TV poll is more sympathetic. Of course it is, because it's like a 90% female audience. They're looking for guilt beyond an emotional doubt. And that doubt is supposed to be based on reason. That's the whole point, right? Verdict should not be based on speculation, guess, or conjecture. So not on evidence we don't have that might or might not exist. That's the definition of speculation. You are to determine the facts from the evidence produced here in court, or the evidence not produced would be fair enough. Reasonable doubt. Verdict not based on speculation, guess, or conjecture. Yep. So there we are, folks. The trial proper is over. We're now on Verdict Watch, waiting to see what's going to happen. Yeah, so Bowles was basically trying to say, if there's any ambiguity, you can't convict. Unless the investigation and the evidence is perfect, you can't convict. By that definition, he could have said, well, there were 200 people on set. Not all 200 were investigated. Right? What's the population of Santa Fe County? Not all those people were investigated. We didn't bring in all the 200 people on the set to be witnesses in this trial, so we don't know what they might have said. And if you don't know, it can't be beyond a reasonable doubt, would be Bowles' argument. No, it doesn't matter what you don't know if what you do know is sufficient to not have a reasonable doubt. You never know everything. There's no such thing as a perfect body of evidence. They know these are real guns. Both Hannah and Alec Baldwin said in interrogation, they know these are real guns. They have safety measures to test blanks because they know live rounds could show up. And they want to make sure they're not putting a live round in the gun. That's why they have these procedures. This is like the opposite of my cousin Vinny. This defense. My cousin Minnie. My Cousin Ninny is what it should be. A remake starring Jason Bowles. My Cousin Ninny. Why do they get 2 ways to prove manslaughter? Because that's the way the statute is drafted. So the involuntary manslaughter is if you're doing an unlawful act and somebody dies, an unlawful act that's not a felony. If it was a felony, you'd be guilty of felony murder. An unlawful act that's a misdemeanor and someone dies, that's involuntary manslaughter. Or if you're doing a lawful act without due care and circumspection, meaning negligently. Negligently in the context of something that's inherently dangerous, like handling a firearm. And the jury could believe either one of those. What I don't like about the law is I don't believe the law should allow a guilty verdict if the jurors are not unanimous in the path to guilt. So Kerry Morrissey told the jury that they're free. If 6 of them believe involuntary manslaughter on one theory, unlawful act that results in death, and 6 of them believe in involuntary manslaughter on the other theory, lawful act without due care and circumspection, that's still involuntary manslaughter. And she's right. That is the law. The jury does not need to be unanimous on the path to guilt, the theory of guilt. They can take different theories to arrive at the same destination, guilty of involuntary manslaughter, and that's enough. I don't think that should be enough. I think the state should be compelled to prove one specific theory. I mean, they could propose multiple theories to the jury if they want, but it should only be a valid guilty verdict if the jury unanimously agrees on one particular theory. But that's not the law. Law Self-Defense member says, I have a real problem with the chick who tossed rounds in the trash, live or otherwise, and that reason alone not guilty. How is it not guilty? What does that change about the fact that Hannah Gutierrez prepared a gun for set that had a live round in it and handed it onto set as a cold gun? The fact that Sarah Zachary threw rounds away afterwards, how does that change what Hannah did? I don't get it. I don't understand that reasoning. Yeah, now they had said they thought they were handling the Denix gun, the replica gun that could not fire a round, but they'd have an absolute defense against involuntary manslaughter. Well, maybe not Hannah, because Hannah should know which one she's turning in, right? But Baldwin would. Member Elman asked, should Morrissey be walking through these jury instructions, or should the judge? The judge already went through the jury instructions with the jury before closing arguments started. Evidence is always thrown away, folks. Not every physical object on the set was collected by the police, right? Trash was thrown away. Props were taken away afterwards, after shooting was closed. The question is it evidence that's relevant to the state's theory of the case? It's not. Whether or not Sarah Zachary had thrown away those rounds, say Sarah Zachary had not thrown away the rounds. All you people concerned about that, pretend that hadn't happened. How's it changed the theory of the case? That Hannah Gutierrez presented on set a gun with live rounds in it as a cold gun. It doesn't make any difference. Of course, it's evidence, but it's not evidence relevant to the key legal argument in the case. Kevin says, again, with stupid jury comment, does Andrew have no faith in the system? Sounds like he doesn't. I have exactly the appropriate amount of faith in the system. You think the system is perfect, Kevin? Do you? You think juries always come to the right verdict? If juries always come to the right verdict, why do we have courts of appeal? Let's see. We all know Alec Baldwin is an a-hole. She's 24. He says, you don't do this, you will never work again. Objectify what someone would do. Where's the evidence of that? Where's the evidence that Baldwin ever told Hannah Gutierrez, ever, if you don't do this, you'll never work again? Where's that evidence? Particularly in the context of being an armorer. But that's not an evidence. I've watched every minute of this trial. That never happened. Let's see. Yeah, I don't mind if you guys watch YouTube and comment here. That's fine. I understand. We have let's see. I'm not YouTube, so I get it. I thought the judge did fine. Usually selecting the foreperson is pretty quick. Usually the foreperson basically elects themselves and nobody else wants a job. There's usually, they've been chatting amongst themselves. In theory, not about the case, but they've been together for 2 weeks. They make conversation. And people get a sense of each other's personalities during that period, and someone will have the stronger personality. Member Jim says guilt and her lawyer should be locked up too. By the way, all of these questions and comments are from the Law of Self-Defense members on the member chat. If you can be a member too for 99 cents, check it out. 2-week trial, 99 cents. After that, it's still less than $10 a month to be a member, but you may as well try it out for 2 weeks for 99 cents. Get all your questions and comments addressed for free. Or you can do a super chat on YouTube for a minimum of $10, and I'll address those questions too. But I think this is the deal you should want. The poll, YouTube is good for the polls, though. I can't do a poll on the member dashboard. And don't forget to hit that like button, folks. How are we doing for likes? Let me take a look. We're at about 50% of subscribers are liking, which is not great. It's not terrible, but it's not great. And hit subscribe. And if you're on mobile, when on mobile you have to, when you leave on mobile, that's when you can like and subscribe. So don't forget to like and subscribe on your exit from the mobile app on YouTube. Let's see. Yeah, she was dressed all in black. Law Self-Defense member Distance says Branca gives Morrissey an A-. Yeah. Oh, maybe a B+. The stuff I thought she missed was pretty important. I don't know how you get the conviction on the tampering charge without talking about the circumstantial evidence of the weeks of text messages, for example. I think she basically threw that away. So that's not good. I don't understand why she didn't ask every witness who said they felt safe on set if they felt differently about it now that Halyna Hutchins was dead. I don't know how you missed that opportunity. Law Self-Defense member Eric says we need a live feed from the aquarium to get the detective's reaction. That would be the Detective Alexandra. That would be the Detective Alexandra Fishlips Hooters Hancock opinion reaction. Hooters. It's fine. Hooters is fine. Let's see. Ryan asks, is a quick verdict more likely to be guilty or not guilty? Is a longer deliberation better for the defense? It's hard to make a rule of thumb. So I tend to think that when it's a really on the legal merits, when it's when it's a strong case one way or the other, I suspect most of the jurors are for the obvious case on the legal merits, whether that's guilty or not guilty. And so the holdouts are for the opposite position. So here I think it's a strong case for guilty on the legal merits. So if it takes a long time to get back with a verdict, it's because someone's holding out for not guilty. Does that get you to not guilty? I just can't imagine that 12 jurors would agree that the verdict here should be not guilty on these facts and on this law. But that's why I don't predict verdicts. Jurors are dangerous and unpredictable creatures. Yeah, so I think a long deliberation is better for the defense, and that a holdout, someone's arguing for not guilty because the facts and laws are clearly guilty. Now, whether they can manage to convince the rest of the jurors of not guilt, but someone's working on it, so that's better for the defense. Lou from the Ark says, I wish Morrissey had disputed Bowles' analogy of the nurse in the medication scenario. Yeah, as I instantly articulated. Thank you very much, Lou. Yeah, I mean, that what a ridiculous analogy. You're right. I can't believe she didn't address that. By his own analogy, his client is guilty. She's the pharmacist, not the nurse. Law self-defense member John says, Andrew, if defense counsel was getting paid, how much do you think he would be billing at? My guess is $7.50 an hour. I don't think that would be true in Santa Fe, New Mexico. $7.50 an hour is a lot for kind of a local regional attorney with no brand recognition. I mean, it's not quite as much as I bill, but I'm an expert in a very particular field. And given his performance, I don't know, $250. But I don't know. Someone did tell me. I wonder if I have it. Someone told me that Jason Bowles, this defense attorney, is listed as a. They didn't tell me. They put in the comments. Is listed as a super lawyer. I thought I opened that up. I have so many tabs open, I can't find it, folks. I wonder if that's. I wonder if I can just look it up. If I can go to superlawyer.com. This site cannot be reached. Super lawyers? Superlawyers.com. Let's see. Attorney name, Jason Bowles. In, I'll say Santa Fe, New Mexico. I actually don't know where he is, but let's see. Oh, well, that's not coming up. But, he may be in Albuquerque. There he is. There he is. There he is. I'll pull this up. Let's see. There he is. Jason Bowles, Bowles Law Firm. Super lawyers. Top-rated lawyer. If you ever suspected that you get to be a super lawyer by paying the super lawyers people money, you nailed it. That's how that's done. That is exactly how that is done. Okay, let's see. Now I lost my chat window. Here we go. Super lawyer. Let's see. Lawful to Shoot says the evidence that Morrissey presented about the live round being on set and in holsters drove in the final nails in the legal coffin. Yeah, but it's not actually necessary for a guilty verdict. So, I mean, it's nice if you believe that, that Hannah brought the live round to set and they were just wandering around for a week on set before somebody got killed. But all that's really required for conviction is that she loaded that gun without actually ensuring that each round was a blank and then handed that gun with a live round in it onto the set as a cold gun. Doesn't matter who brought the round. Doesn't matter where it came from. Doesn't matter when it showed up. Doesn't matter. Doesn't matter if it was dropped on her cart and she thought it was a dummy, because she's supposed to check before she puts it into the gun. Law self-defense member Mark says, the one time I was on a jury, I volunteered and was selected as foreperson since nobody else felt strongly about the task. Yeah, that's usually what happens. I mean, that's what I would do. We're going to spend time just staring at each other, trying to figure out who's going to jump first. I'll do it. Let's get this over with so we can start deliberating. Law Self-Defense member Dave says, I've served jury duty twice and served on 3 juries. It was shocking how gullible and, yes, dumb some jury members were. It was shocking to think they sat on the same trial as I did. Luckily, in 2 trials, judge allowed us to take notes. It was, we have to remember, folks, the average IQ is set by design at 100. 100. That means half the country's got below 100 IQ. And those people go on jury duty too. So, and most people are not really rational creatures. Most people are emotional creatures. Reason is something human society fabricated so we'd get better life results than just acting on emotion. But inherently, we make emotional decisions. We're rational only on a kind of hit or miss basis. That's why there's so many rules of evidence to exclude prejudicial evidence, evidence that might excite the emotions of the jury but doesn't have much probative value, doesn't help the jury rationally arrive at a conclusion about the facts of the case. Let's see. Member Elman says, I think he means Hannah Gutierrez here. I think Hannah Gutierrez is convinced that what she did was enough. I think she never checked. I literally think she never checked. I think she just assumed every round was a blank and she didn't need to check. Everything she was putting in the ground in the gun was a blank. I think no one was more surprised than Hannah Gutierrez when a live round came out of Alec Baldwin's gun. The trouble is, it was her job to make sure it wasn't a blank. She's not allowed to be surprised. Let's see. Distance says, why was I going to guess super lawyer? Yeah. Oh, now here come the links of the super lawyer. Yeah, I'm surprised. I'm surprised when I searched for super lawyer that porn didn't pop up. Kevin says, I know one thing. There's no friggin' way I'm ever driving through Albuquerque, New Mexico with a firearm with this bulldog. If you meet Carrie Morrissey, she's not a prosecutor. She was specially appointed. She's a special prosecutor for this case. She's normally a defense lawyer. He's also admitted in Texas. Good for Texas. Oh. He's been super for 4 years. Yeah. You know who's never been a super lawyer, folks? I've never been a super lawyer. Steve writes, I don't know if this is true. This is just in the chat, but Steve in the chat writes, Mr. Bowles served part-time in the U.S. Army, New Mexico National Guard, probably as a JAG, but good for him. Thank you for your service, sir. I came this close to becoming an Army JAG back in the 1990s, but I was in the midst of a very, very bad marriage, and I didn't think I could risk it. Too bad, because the marriage folded anyway. It would have been a lot of fun, but yep, I never followed through. And he's a partner at Pure Life Medical Cannabis Company, an organization that's devoted to highlighting the benefits of medical marijuana and making it readily available to those in need. You think Bowles is smoking his supply? You think that would explain his demeanor? John says, Andrew, do you think the general anti-gun attitude of the general public will factor into the jury deliberations? Not in this case. It's not really a gun case in like some citizen armed himself with a gun and shot an armed robbery suspect. If only he hadn't had a gun, this wouldn't have happened. The guns here are acceptable because it's Hollywood guns, right? I don't know that Jason Bowles smokes marijuana. It just says here that he's a partner in a marijuana company. I don't even know if that's true, but it wouldn't surprise me. Law Self-Defense member Mark says, even Mr. Cuckoo, the defense firearms guy, could be on a jury. Can you imagine having that guy on a jury? Mammy. Can you imagine Mammy on a jury? She'd be like, "Hey, I was a script super. I remember everything from this trial." That lawyer wore the same tie twice in a week. Mammy. Law self-defense member Kent says, Aristotle, man is the rational animal. Jonathan Swift, man is capable of reason. Some people are capable of reason. Not all that many people. Very few people do it in a rigorous way very often. There are people, genuine scientists, engineers, lawyers, I mean the good ones, because it's necessary. If you're not applying powers of reason, you're not getting good outcomes, right? Bridges fall, drugs are bad, clients get convicted or lose in litigation. Oh, Steve says, I copy pasted that from his super lawyer page. Is that on this? Is there a profile? View profile. I wonder if it'll let me. Yeah, I'll just read the profile. This is funny. Jason Bowles is an attorney at and the founder of Bowles Law Firm in Albuquerque, New Mexico. Oh, let me pull it up, actually. I'll pull up the tab. Here we go. He is a criminal law and personal injury attorney with over 24 years of experience practicing law. He has handled cases involving criminal defense matters such as wrongful death, medical malpractice, auto accident, white-collar crimes, and so on. What? That doesn't even make any sense. He's handled cases involving criminal defense, and the examples he gives of criminal defense are all civil litigation. Wrongful death, medical malpractice, auto accident, white-collar crimes, I guess would be criminal defense. Fair enough for that one. Wrongful death, medical malpractice, and auto accident, that's all civil litigation. That's personal injury and stuff. That's not that's not criminal defense. And by the way, his kind of emotional affect might well be much more effective in medical malpractice and personal injury law. A lot of emotions there. With a genuine concern for his clients, Mr. Bowles provides sound and knowledgeable counsel for his clients. I don't know about that. He offers dedicated and aggressive legal services to his clients. Like when he sat in that interrogation room with Hannah Gutierrez for 2+ hours and did nothing. Firmly committed to their needs. He helps his clients navigate through the difficult time in their life and communicates regularly with them in prison. I added the imprisoned part. And communicates regularly with them and keeps them informed throughout the process. Graduating high school from Goddard High School, Mr. Bowles has a bachelor's degree in finance from the Lubbock Christian University. He's a JD from Texas Tech University School of Law. He's licensed to practice in the states of Texas and New Mexico, which makes sense, right? I mean, they're adjacent to each other. Bowles served part-time in the U.S. Army New Mexico National Guard. He's a partner at Pure Life Medical Cannabis Company, an organization devoted to highlighting the benefits of medical marijuana and making it readily available to those in need of it. Mr. Bowles served as a clerk for prominent judge in the U.S. Court of Appeals for the 10th Circuit, focusing on drug crimes and immigration. He was also assistant attorney at the United States Attorney's Office, where he was a trial attorney in drugs, guns, white-collar, and violent crimes prosecution. He was a U.S. AA. Did he suffer an injury? Some kind of traumatic brain injury? He's honored for his exceptional work in the legal field. Mr. Bowles has a very good rating on Abo, which is a lawyer rating site. Very good. It feels like kind of a pat on the head rating. All right, back to thanks for that. Thanks for that, Steve. I think it was Steve. Yes. Okay. Dave says, Andrew, we are happy you chose the path you did. Proud platinum member, even though I'm not a super lawyer. Michael says, Andrew, assuming a conviction, do you think she will serve more than 9 months in the pokey? So, we imagine that it's common for judges to not give the maximum sentence, but it happens all the time. I mean, the jury arrived at a verdict. The jury says you're guilty of the crime. You're guilty of the crime. The judge is like, you're guilty of the crime now. And the sentence for the crime is 18 months. So might she mitigate? I mean, she seems like a pretty level-headed judge to me. If she, frankly, I think 18 that she's only subject to 18 months is ridiculous for involuntary manslaughter, especially given the aggravating circumstances of this case, that she loaded a live round into a gun on a movie set that then went on to kill somebody, when with the slightest of effort she could have confirmed that it was a blank, that it was a dummy, and not had this death happen. I mean, I think it's just utterly egregious. If it were me, she'd get the whole 18 months. I wouldn't even think twice about it. I would just be unhappy I couldn't give her more time. And 18 months is not that much. So why mitigate it? I mean, isn't 18 months of, somebody died because of her malfeasance. I would not be inclined to mitigate. Elman says he's an ambulance chaser. Hey, some of those ambulance chasers make a lot of money. Alec Murdaugh was an ambulance chaser. He made a lot of money, stole a lot of money, and made a lot of money. Wendy says he was an AUSA. I've worked with a lot of those. None were this low key. I can't believe he was a AUSA, but that's what it seems to say in his bio. Maybe that was before the weed. John says, don't forget, Attorney Bowles probably took this case as a client portfolio and prestige building case. This case will soon appear on his website. And I don't have a problem with that. But then do a good job. You still have to be effective, zealous counsel for your client. Don't just sit there in an interrogation and take notes. Let's see. In AUSA for 5 years, 1996 to 2001. Maybe he was a different man in 2001. That was a long time ago. Elman says, I think the fact it was a gun that caused the death makes her sentence high. Yeah, I mean, not to me, it wouldn't be that it was a gun per se, but that it was an inherently dangerous instrument, whether it had been guns or explosives. Say she was in charge of special effects, and one of her special effects was done recklessly and killed somebody. So then it's not a gun, but it's something explosive that could kill people. Dangerous drugs, chemicals, heavy equipment, all that kind of stuff. DJ said, I assisted putting a guy in a federal pen for 13 months for stealing $130,000 from an elderly lady. Yeah. Yep. Kent Master says, Sonny Hostin was an AUSA. I'd forgotten that, actually. There are a lot of dumb ones. Well, we know why she got her job. Those reasons wouldn't apply to Jason Bowles. Sonny Hostin is not a very bright person. I debated her once, as many of you know, at a UC Berkeley Law School stand your ground debate, and she was on the other side. Of course, I was pro stand your ground. She was anti stand your ground. This was right after the George Zimmerman trial. That was not a stand your ground case, but Berkeley Law School invited me out to participate in this debate, so I went. And she was on the opposing side, and she what she did as her argument against stand your ground was read a Sotomayor Supreme Court dissent having to do with affirmative action. and of course, she had the facts of the Zimmerman case wrong. In fact, during the debate, I bet her $100 that she had the facts wrong, and she said she agreed. And right after the debate, I texted her, I emailed her the correct facts, which was the opposite of what she had said. And she's never paid me the $100 all these years later, 13 years later. Sonny Hostin still owes me $100. If you'd like to learn more about that, and I think we even have the video of the debate, lawofselfdefense.com/Hostin, Hostin. I think we have that up. Let's see. Whoever appointed or elected Fannie Willis? I believe she's elected. You can run, and then the people in that jurisdiction elect you. Who elected Marilyn Mosby? Who elects all these George Soros prosecutors? There's nobody runs for these races, folks. They're normally very low budget races, a few thousand by each side. So if George Soros comes in and he dumps $100,000 into a race, that's not a lot of money to him. But $100,000 is going to be 20 times as much money as the opponent running for the prosecutor's office is likely to be spending. And so you just bought the seat. The qualifications have nothing to do with it. DJ says this is the guy who got 13 months for stealing $130,000. The judge would have given him 3 years, but the perp brought a check to sentencing for the total amount that he stole. Well, that's fair. Still got 13 months. That's fair. He only paid it back because he got caught, right? So we have to keep that in mind. Let's see. Steve sent a Facebook link. I don't think I'm signed into Facebook. Yeah, I'm not signed into Facebook. I'm never really on Facebook. We use Facebook for marketing for law self-defense, but he had rich in-laws, $130,000. Why wouldn't they let him sit in there another year and a half? What harm would that? I guess maybe he had kids. They don't want their grandkids to be without their dad for 3 years. Quite the dad. All right, let me see if there's any super chats. We are now officially on Verdict Watch, folks. Verdict Watch. Let's see. What do I have to do here? There. Oh, there are some super chats. All right, let me take a look. There's some YouTube $10 super chats. Also get read. Here's a $2 one, but I'll say it because it's kind to me. Brian, $2. Thank you, Brian. Law of Self-Defense channel rules. Rules, even though I'm not a super lawyer. Thank you, Brian. Charlie Ecker, $10. Not only is Hannah's career kaput, so are the careers of her lawyers. Triple funeral. Thanks for the hard work. Use this sawbuck for the court's hairbrush fund. The court's hairbrush fund. They can buy their own hairbrushes, Charlie. I don't know if, I'm sure Jason Bowles is going to continue to get plenty of clients who don't know how to tell any better. They didn't watch my coverage of this trial. They may think he did a fine job. Monica Barreras, I mean, I wouldn't hire her, but it doesn't mean she won't get clients. $10, Tall Skinny Geek says, does he think that beyond a reasonable doubt just means you have reasonable questions still left unanswered rather than the elements of the crime are sufficiently certain? He seems to be suggesting, Jason Bowles, defense attorney, seems to be suggesting that unless you have universal, omniscient awareness of everything in the universe, you must have a reasonable doubt because you don't know everything. That's not how it works. You could not know 99% of the things, and the 1% you do know is sufficient for proof beyond a reasonable doubt. That's how that works. Wow. All right. Well, I think that's pretty much everything, folks. So I'm going to go ahead and wrap up. I will be keeping an eye on the news. If I don't think I have anything that really conflicts with Verdict Watch, so I'll try to keep my eyes on things. And as soon as we get a verdict, so keep your eyes open. I will do a flash Verdict Watch, Verdict stream if it happens. I'll schedule an email or draft an email that I can send out right away. And of course, I'll be on Twitter. So if you don't follow me on Twitter at Law Self-Defense, that would be a good thing to do. I'll post there if a verdict's in and we're about to go live, and get on my email list. I mean, a great way to get on the email list is to buy the book, and I'll send out an email as well as soon as I know something. And today I will try to remember to shut the stream when I sign out. Poor Shane. Everybody was trying to get a hold of me. I'm sitting behind my desk thinking I'm off the air. All right, everybody. So I'll just remind all of you, if you carry a gun. So you're hard to kill. So your family is hard to kill. That's why I carry a gun. So me and my family are hard to kill. Make sure you know whether or not it's got dummies in it, not your family, the gun. If you carry a knife, if you carry pepper spray, if you study jujitsu, so you're hard to kill, then make sure you also know the law of self-defense to make sure you're hard to convict. If you're ever compelled to defend yourself, your family, or your property, get that book for free at lawofselfdefense.com/free book. And until either we get a verdict or if we don't have a verdict, I guess I'll just do a regular show tomorrow around noon Eastern time. We'll have to play that by ear. But until we meet again, hopefully soon, I remain attorney Andrew Branca for the Law of Self-Defense. Stay safe.